Evening, everybody. Welcome to part three of subject two purchases. Tonight we get a little bit further into it. First, we're going to review a little bit about what we are doing. So tonight's making the purchase. We have one more, which will be the exit strategy, which will be on Friday evening. And tonight we're going to just review a little bit about the first two. Then we'll get into talking to the seller, the mechanics and procedures, some scenarios, and we're going to talk about the insurance, which is important. Okay, so course review number one. First of all, is there anybody that was not with us on part one or part two? Just put me in the chat. But I think everybody was, but I just want to know.
I think there might be one or two people that weren't,
Is anybody saying me?
you know.
Okay, so I assume everybody's been here. All right, so we reviewed part one. We talked about land trusts, that they're very important, especially when you're doing a subject to. We don't want to raise any red flags, and the banks see all the time people putting their homes into land trust for estate planning purposes. So the only way they can do that is you put it into a land trust or a living trust because it doesn't go through probate. Who wants to go through probate? So that's why we use land trusts and not LLCs, because now there's obviously been people that took them in LLCs and haven't been caught, but majority of the ones that have been caught were LLCs, and banks are getting a little bit smarter about it. There's legislation coming down, so definitely want to close in a land trust. The contract is basically a land trust is a contract between the trustee and the grantor, so it's not an entity, doesn't file for any checking accounts, doesn't get an EIN number. It's nothing more than, it's similar to like an operating agreement in a LLC. So basically, it's the operating agreement of the land trust. It spells out the powers and responsibilities of the trustee, and the same thing for the beneficiary, which was the grantor. So we're saying that it is an agreement because the grantor is the owner or seller who's transferring the deed to the trustee. So in essence, it really is, but usually the grantor becomes the beneficiary. It's known as a revocable grantor trust, but all 50 states recognize a revocable grantor trust. There's only 6 states, as we talked about, that have statutory laws. All the rest go by common law, and most of the states that don't have a statutory law follow what's called an Illinois land trust, because Illinois was the first state to use them. So everybody recognizes the Illinois land trust, and they use the laws of that. Individuals or participants include your grantor, which is usually the owner who's granting the deed into the trust, who then becomes the beneficiary. The beneficiary is the owner of the trust, owning the beneficial interest, which is similar to owning stock in a corporation. The trustee owns the real property. That's why it doesn't go through probate, because your name will no longer be on the property when you put a property into land trust. The trustee's name will be on the deed, and the trustee is a fiduciary. They can't do anything without the beneficiary's permission. So that's basically how a land trust works. Any further questions on land trusts, or we'll move on?
You can open up your mics. You don't have to put it in the chat.
You see Barry Paul again. You
Okay.
mentioned something about the trust not having a bank account.
Correct.
You may be covering this a little bit later on, but I suppose the question is, how do you collect rent and pay expenses and everything like that in that
Okay,
case?
that's a good question. I believe we covered that either the first night or the second night, but that's a good question. So let's go over it again. So let's paint a scenario. You buy a house, right? And you buy it subject to, you took title in a land trust, and you set up 2 LLCs. You set up one LLC to be the trustee, which is an option. You don't have to. It could be, you could hire somebody to be the trustee, but nevertheless, the way we've been doing it, which is what you asked, we set up LLCs to be the trustee. And then you need another LLC to be the beneficiary. Now, you have to sign leases with your tenants because you bought a rental. Those leases can be signed by the trustee, because they're the owner. And if you are the trustee, then yes, you could open up a bank account. There are most attorneys who are trustees do not want to receive any money. There are some who will receive funds, but not on a daily basis. Like if there was an insurance check or something like that, like real one-off, where they'll deposit it and then issue a check to you. But the way you would want to do it so that you don't have to open up a checking account in the trustee's name, You would then have another LLC, which is what we're going to go over on Saturday. That would be a management company, and that's the best way to do it. And have that management company be sign the leases in favor of the landlord. In other words, they've been appointed by the landlord, and in that way, then you would open up the checking account in your management company, and then depending, and again, kind of going to Saturdays, but you should always have a general account that doesn't own anything. And that general account is where you'd want to put all your bills and everything, and maybe that's who then the management company would send the money to. Are you planning on being with us on Saturday, Paul?
Yes, if I can
Well,
last through to there.
we will definitely be touching on what the question you just asked and going on the structure of how to do that.
Okay, no worries. Thanks.
Anybody else?
I had a question about your last bullet point. Participants can be a beneficiary and trustee. Can the beneficiary be a personal or a family revocable trust?
Yes. Matter of fact, that's not a bad way of doing it. If you have a living trust or a family trust, which is basically the same thing, many people will make the beneficiary that. But then again, you can do that. You never want to deed the property directly into your living trust, because in your living trust or family trust, you might have stocks, you might have antique cars, you could have collections, you could have crypto, you could have all kinds of things in there. And now you have a rental that you've deeded to the living trust or the family trust. That's how you took title to it. And now there's a slip and fall, and there's an accident, and they get a judgment. Now everything that's in that living trust or family trust is up for grabs. So what we do is we put all properties get into their own land trust, which is a form of a living trust, but so it works identical to that, but you just can only hold land, or it could hold mortgages too, but you're better off having a paper trust for that. So now we have the land trust, and you can make the beneficiary of the land trust the living trust. You can do that. That's more for making it harder for an attorney, and because you could then have or you could have an LLC and have that LLC be owned by a trust, and then that trust be owned by another LLC. So you can do all kinds of layers if you want. But sadly, we're going to get more into how to simplify and to make yourself asset protection, asset, what's the word was for, lawsuit protected, so that nobody could sue you. Well, they could sue you, they just won't get anything. So you've really protected your assets from anybody getting them. And that's the way you would do it. But still, if we combine your question with what Paul just asked me about getting the money, you still wouldn't really want the monies being delivered directly to the living trust or the family trust. It should go into another company that you would form that to be a management company, and then that could funnel the money if you wanted it to go to the living trust. That's more of an accounting and more estate planning purposes, not so much of a legal question. So because we have a lot of options, there's no set way that you have to do it. I know that might not be a very clear answer for you, but it's just too involved for me to say definitively to go ahead and do that. You can, as I said, and many people do, but it's more for asset protection and trying to make layers is why they do it.
Thank you.
You're welcome. Anybody else?
Nothing in the chat at the moment.
All right, then let's move on to part 2, which we talked about last night. So last night we talked about subject 2, which is making the payments for the seller, not assuming it. I've got I've been reached out, and I've been helping somebody for a while, and finally got all the paperwork tonight. And basically, they making the payments for the seller, their contract, there's just so many bad contracts, and it's usually the wholesalers, unfortunately. And if there's any wholesalers on it, no dig on you guys or anything or a reflection on you, but the contracts that I see, and some of them are almost the same ones that are used. And this particular one, they said that the buyer was assuming the loan, and yet then they had them sign a subject to addendum. But it's conflicting. Assuming means that you're taking over the loan by qualifying to the bank. When we say we're just making the payments for the seller, we're not telling the bank, so therefore we're not getting a new mortgage, and we're not assuming the mortgage. Assuming a mortgage is a legal terminology that means that you apply to the bank and they check you out the same as if you were applying for a regular loan. In other words, credit history, income, and all the rest of that. We often used when the seller is in trouble because we are their best option. We talked about what options do they have. We're actually going to go over that a little bit again tonight. We talked about, if they have very little equity or they're upside down or they're about to be foreclosed on, they really have no option other than us. We're their best option. There's multiple benefits that we talked about for the seller and the investor. Obviously, for the seller, they can preserve their credit, especially if they had a home that they've already moved out of, and they're upside down, or they have so little equity in there that if they tried to sell it, it would cost them money. So now they don't want to ruin their credit. So basically, we can preserve their credit by taking over and making the payments because we're not buying the house to resell it. There's no equity. We're buying it because we've done our homework and our due diligence, and we found out that what their monthly payment, which is principal, PITI, principal, interest, taxes, and insurance, is far less than what we can rent it for, that it shows that you can make a nice cash flow. So that's why we buy it. That's the benefit for the investors. And of course, we're not putting our name out there. We're not using our credit or any of that. Buyers, sellers, and the bank all create risk in these deals. They can. We talked about the risks, that and how we protect the seller, because sometimes too many people take over subject to and they leave no recourse. They don't either sign a wraparound mortgage giving back to the seller, nor do they do the conditional assignment of beneficial interest that we talked about last night. That would protect the seller. They just do an assignment. They either buy it directly in an LLC and that's it, or if they do buy it in a land trust, they just do a plain assignment that has no recourse, no ramifications, that if the buyer stops making the payments, there's nothing the seller can do. So any questions on what subject to is and what it's not? Okay, if not, let's okay, yeah, let's move on. All right, so there's really two keys information that you need when you're doing a subject to or any kind of creative deal. You really can't make a creative offer without having these two items that you need to know about the house or the seller or their mortgage. You need to know two things. Because if you don't know these two things, you can only make a cash offer. Anybody want to take a stab at what the two things are?
Credit and cash? No, credit is one.
You need to know what the seller owes and what the seller is asking for. These become very important because, first of all, you need to know there's actually that's a mistake on there. What they owe, yes, it should be what they owe, and in addition to what they owe, what the monthly payment is. I don't know why that part was left off of that. What you owe would be the balance of the mortgage, right? But the balance of the mortgage, well, actually, I take it back. You do need this here. There's two parts to this, and this was written a little confusing. Okay, you do definitely need to know what the seller owes and then what they're asking. The reason that this is being written this way is the next couple of slides is going to be, or the next slide is going to be about, not all the time do we get a lead that's in trouble. Obviously, if the owner is already in foreclosure and that's your lead that you're going into pre-foreclosures, well, then you already know that they have a problem. At that point, you would want to know, what's the balance of what do they owe? You'd have to know that. You also want to know how much to bring the loan current. But many times you could get leads. You could either have a website where you're getting warm leads coming in that, yes, like Eric has a website that says Eric Buys Homes. Many people do it that way. Whatever kind of website you have that you're tracking, or you're doing mailings, direct mailings, to a zip code, so you don't know when you mail those out. Or is somebody, it could be an investor that just bought it. It could be a homeowner that's perfectly good on their credit and wants to sell. You really don't know. So we have we've told you guys quite a few times already that Eric and I have a joint venture partnership program. And when you're in our program, we have a specialized lead sheet that's also a conversation, and it's a gathering of information about the house, but it's also a conversation. And once you find out what the seller owes and what they're asking for, we talk about there's a percentage difference. And so then perhaps, because there's three ways, and there's three questions on this lead sheet, and you'll know which one of those three questions, and they're three buying questions. So you can either buy a house subject to, we call that where you sell for what you owe. That's what the question would be, which you're going to see in a few moments. The second thing would be if they have a bunch of equity, but it's not free and clear, you might ask them, will you sell on a lease with an option to buy? And then the third way would be owner financing. There is no fourth way of buying homes creatively. You might tell me, well, what about a wrap? That's a hybrid. It's still a subject to, because the homeowner's not paying it off. So there's only three creative ways to buy real estate. That's subject to, lease options, and owner financing. Now, if you don't know the situation, that you don't know whether they're perfectly up to date or anything, then this is what's going to make sense to you on the next slide. So, framing our conversation. So this is Nicole. She's going to help us. I couldn't get anybody live to come on with us, so I made pretend. So this is Nicole who'll be helping us with the presentation today. She's going to play the part of the person that we're talking to about doing a subject to deal with her home, and you'd be calling her maybe blindly. It could be a Zillow ad or whatever, or it could be with an incoming lead that said, yes, I want to sell my house, and you're following up to call back. So, hi everyone. I'm excited to help you learn about the conversations you're going to have with people when lining up subject to deals. So, from this point forward, we're going to talk a little bit. So here is the first thing that we want to know: the importance of and asking for. If the quantity, the very little left of 15% or less in equity, then we would ask them, will they sell for the O? So let's say they're asking $100,000 and they owe 90,000. Well, then they only have 10% equity. And we're doing this not the difference between what they owe and what it's worth. We're doing this between the difference between what they owe and what they're asking. For example, you could easily stumble across a home maybe for $100,000 that they're asking, but it's worth 115 or 120, but they're only asking 100, but they owe 90. So we go by the difference between what they're asking and what they owe. So if they owe very little, then we generally ask them, would you sell for what you owe? So you've discovered what they have, very little equity. They're either upside down. So what options do they have? Now, if I assume everybody was with us on the last call. So what are the three options or the two options that they have before we give them an option? Anybody? Nobody remembers from last night what their options are when they're upside down or have very little equity? They've moved, they own a house, they owe too much, they can't sell it unless they do what at the closing? Come on, guys. It's participation here.
Bring cash to the table.
Bring cash to the table. Yes, who said that?
Alex,
Alex. Oh, you're on. Okay, Alex. When I showed up before, I was saying, where's Alex? I didn't see you on, so you must have came on late. Okay, yes, Alex is correct. What about the second option that they have?
Walk away.
Walk away, exactly. So there's your three options. They can sell the home for whatever they can get and bring cash to the closing to make up the shortage. Nobody really wants to do that, but occasionally people do. They're very morally the way they were brought up, and you have a responsibility to take care of it. Or they could just walk away from the home. Of course, it would take, the bank will not just take the loan. You have to go at least 3 months late, and then the bank will say, okay, we'll take cash for keys, maybe, or you just sign it to them, what's called a deed in lieu of foreclosure. But unfortunately, the credit gets dinged. But if they already own another house, they may not care. They're not, because it only takes 3 or 4 years to reestablish the credit enough that they can buy a car or get some credit cards or things of that nature. But of course, they can accept our offer and preserve their credit, because we're not buying it, as I said a few moments ago, to resell it. We're buying it for cash flow, right? So, all right, so we get to this. So once we get to the point in the conversation of talking about the reality of the situation, in the beginning, you're going to make a friend, and it's really important to make a friend. I don't have the sheet on here tonight, but one of the things, this is even part of this, but we're going to get to talking about in a few slides about how is somebody going to sell you a house if they don't like you? So you have to get them to like you. And there's a trick. Well, actually, I'll save it to the part when we get to that. Okay, so once you get to the point in the conversation where you're talking about the reality of the situation, and you find out that they have very little in it, you say to them, hey, if we pay all your closing costs, will you sell for what you owe? Because you found out they have 15% or less in equity. So now what is your seller thinking? Well, did they just say he's going to cut me a check for the balance of my mortgage? Because if a seller was asking 100,000 and they tell you they owe 90,000, and you ask the question, will you sell for what you owe? don't you think that the seller is going to think that you're going to cut them a check for the 90,000? Why would they think anything else? I mean, you put a house up for sale, you expect to get paid for it. They're not expecting it. They don't know anything about subject to. They don't know about lease options or creative financing. You say, well, you sell for what you owe, they expect to get paid. But obviously that's not the way we're going to do it. Now, you cannot continue unless you're in our program, continue throughout the conversation with allowing them to think this. You must be honest with them, and you need to explain to them as simply as and clearly as possible that no, we can't buy your house. If I laid out the $90,000, I can't resell it to make any money. And if I lay the $90,000 out to keep it as a rental, and maybe I can rent your house for $900 or $1,000, I'm just not going to make a good enough return on my money. I can do a lot better. So no, the only reason that we're interested in your home is for cash flow. So we cannot pay it off. And the only way that we can do that is by taking over and making the payments for you. And then you'd have to go in and explain it to them. If you're in our JV partnership program and you get to that question and you say, will you sell for what you owe? And they say yes, regardless of what question you're asking, but we're talking about the first one, selling for what they owe, subject to, your answer would be, great. What's the best time that I can call you back with my senior partner? And he'll explain exactly how the program works, and you could ask all the questions to them. And if you're in our program and they ask you a question that you're not comfortable about, which you don't have to worry about because you can get started immediately with no education, your answer would be, gee, I'm really not the best person to answer that. You know, my contribution to the partnership is I find nice folks like you, or I find nice folks that have a situation that we can help them with. So what's the best time that I can call you back with my partner? So that would be the answer to it. But if you're doing this on your own, you're now going to have to go into and explain how subject to works without talking over their head, right? You'd have to do that because you can't mislead them. One of the things we have to do is full disclosure. You do not want to find yourself in court, no matter what you get them to sign on the contracts. If you haven't really made it very clear to them and you're talking above them, or then they'll come into court and say, you told me you know different things, and you'll lose. So you don't want to go to court. So so they'll go through various emotions while you're having this conversation. This sucks. I can't trust them. They don't know. You're asking to sell the house for what I owe, and you're going to tell them you're going to transfer the deed into my name, and I'm going to make the payments, and you expect to trust me. I'm a stranger to them. They're not feeling very comfortable. So you've got to change that. You got to get them to like you. And I told you that I would tell you a little trick. So if you call, let's say you're calling on an ad, or somebody responds to you and you see the number coming in because you called, maybe you saw an ad and it was in Orlando, let's say, since I'm in that target market, but the phone number is a New York phone number, or it's a Miami 305 number. It should be a 407 or a 321 or a 689, which are the area codes for Orlando. So if I'm calling, and the way it would start off, let's say I was calling about a house, cold calling at a Zillow or some place that it was advertised. Hi, my name is Barry. I'm calling about that house. Is it still for sale? Yes, great. Hey, what's your name? Bob. Hey, Bob, you got a few moments so I can get some information about the home? You know, I saw it in Zillow. I do have some information, but sometimes the Zillow isn't correct. But before we get started, hey, Bob, you know, I'm calling about your home in Orlando, but I see you have a New York phone number. Am I speaking to you in New York, or are you here in Orlando? Now, you only can get to do this trick, and I'm telling you, if the cell phone area code doesn't match with the houses, which today that happens so many times because people don't change, there's no more long distance. So Bob turns around and could tell me a couple of different scenarios. What if he says, yeah, that's my house in Orlando, and I live in Orlando, but I used to live in New York, and we grew up there. I got a job transfer, but my children went to college in New York and they stayed there, and I've got grandchildren now. And, you know, I get maybe once a month, I get to fly back to New York. And so I got to sell the house so I can be near my grandchildren. Oh, really? How many grandchildren do you have? Get them talking about the grandchildren. I guarantee you that the grandchildren are way more important, and they love to talk about that more so than the house. And so the trick to getting people to like you, I don't care if it's a romantic relationship, a friend relationship, a business relationship, when you get people talking about what's most important to them and show that you're interested, show empathy, show that you care, or you're excited, or you're happy for them, or you're sad for them, that's how people get to like you. If you meet somebody and they tell you something and you say, oh, you think that's bad? Let me tell you what happened to me. That's a conversation stealer. That's the opposite way to get somebody not to like you, where all of a sudden, you know, they were about to tell you something that happened to them, good or bad, and you say, and it's like oh well, let me tell you what happened to me, and you're topping their conversation. No, don't do that. You want to listen to them. Now you're speaking to them over the phone, so you really can't. If I don't have my cameras on right now, but some of you might be. You're looking at me, nodding your head, but you can't do that over the phone. You're only having a conversation, not a Zoom meeting, so you have to feed it back verbally. Wow, that must make you must be so proud of having grandchildren. Oh, that must have been so cute. Or it could be maybe Bob says, no, that's my parents' home. I live in New York. My dad just passed away. Oh, I'm so sorry to hear that. How old was dad? 95. Oh, God bless him. He lived a long life, but I know it hurts. I lost my dad too. You know, and he goes on to say, yeah, and I'm putting the house up for sale. I brought mom back to live with me. Oh, God bless you. That's so great because we buy a lot of houses here in Florida, and there's a lot of senior citizens, and the children don't even come down. You're showing empathy, showing that you care. There's an old saying, you might have heard it many times before, that that seller or buyers, whatever situation, whatever hat you're wearing, they don't care how much you know until they know how much you care. So you have to show empathy. I hope that makes sense to you guys. So doing that, getting them to like you, there's obviously different things that we would be saying to them so that, hey, wait a second, this starts to make sense, that you're sounding legitimate. And then maybe I can actually help, this guy can help me because you're getting them to like you. So my favorite saying is always remember this: if they like you, they'll listen to you. If they listen to you, they'll trust you. And if they trust you, they'll sell you their home with terms or such as subject to. So common objections that you're going to get from them is, I need to talk to my attorney about this. How do I know that you'll make the payments? Why should I trust you? Right. So let's start off with the attorney. Right. So yes, we recommend that you talk to an attorney. Matter of fact, if you've done any of these sales before, or you've seen the contracts, there's an addendum, and we always have in the addendum that we make the seller initial that, yes, I acknowledge that we've been recommended to have this reviewed with our own attorney. Whether they do or they don't doesn't make a difference, right? So, but if the attorney tells you not to run, if it doesn't tell you to run, then you might need a new attorney. Now, we're not trying to talk out of it. Might sound odd me saying that to you, that I'd be saying this to Nicole, that I'm not trying to talk you out of it, but it's a good idea. But if the attorney doesn't tell you the risks that are involved, then he probably doesn't know enough about subject twos, and you might want to find another attorney because there are risks involved. But I'm going to tell you all those risks. Now, if you tell all those risks, all the things that an attorney is going to tell them, then when the attorney tells them those things, they're going to say, that guy Barry was really, I could trust him. He already told me all that stuff. But on the other hand, if you didn't tell them these things, now they're going to come back to you, and now you're going to play an adversarial position because you're going to have to overcome objections, and generally you're going to lose them most of the time. You might be able to overcome them, but certainly I think you can see how you will build that trust more so if you disclose all the different things and then explain to them how you're going to protect them on all those different things. Like, how do I know you're going to make the payments? Well, if I don't, here's what's going to happen. Why should you trust me? That you have no reason not to mistrust me. And since I am just a number, I'm just a voice over the phone, I'm going to give you these protections that if I don't make the payments, you're going to take it right away from me. So it's very important to do that. And like we said, there are risks involved that the lawyer should tell you about. It should be the due on sale clause. Buyer can stop making the payments. This can hinder you from buying another home. And that's a real important one. That is very important that you ask, or sometimes they'll tell you like why you're selling. And the little trick that I told you before kind of tells you why they're selling, because they don't want to live there anymore, that they already have another house to live in. But if they don't tell you that, or the cell phone number matches exactly where you're calling, then you can't use that trick. And our lead sheet, after you get the information about the house and you're doing a little bit of chit-chatting before you ask the mortgage payment question, because they got to trust you before you even get to the part where you ask them, do you have a mortgage on this property? Because if you don't make a friend and you ask that question, they're going to say, Nicole may say to me, so Barry, you want to know my personal information, or do you want to buy my house? Why do you need to know my mortgage information? Which would be another objection. But if you've been handling it and made a friend before you get to that, you won't get to that part. But one of the things, if you didn't have that ability, then you would say, hey, do you mind if I ask you why you're selling? Oh, well, we want to go buy another house. Oh, you want to buy another house. Now, you have to protect them. I'm sure that most people on here understand that when somebody gets qualified for a loan, there's something called debt to income ratio. And so if they don't have a big enough income to qualify for this mortgage that you're taking over and the next mortgage, that's going to become a problem. And how we handle that one is then you would buy, and it's okay, I've told you last night, and I think I told you the first night, it's okay to buy on a wraparound. I just don't want you selling on a wraparound. There's no reason to. But when you're buying, you're giving, that's you giving back to the seller. And so you would say to them, listen, I'm going to give you a wraparound mortgage. It would be, and if there was no equity, and it's just maybe you're giving them equity, giving them the cash, but there's no financing equity, then you would use what's called a mirror wraparound mortgage. A mirror wraparound mortgage, let's say that Nicole has a mortgage for $100,000 and she has $1,000 monthly payment. So a wraparound mortgage wraps around the first mortgage and includes every term and clause that's in that first mortgage, including the balance, the amortization schedule, the interest payment, the monthly payment. And so now your second mortgage, which is the mirror wraparound, because it's mirroring the first, would be exactly the same. You owe $1,000 per month to the seller. It's not going to, you're not going to owe $200,000. You're not going to have to make $2,000 monthly payments, 1,000 to the seller and 1,000 to the bank that you're taking over. No, it's the same one. So, and then you would set it up with a servicing company where you would pay the 1,000 to the servicing company, and the servicing company then would pay the bank. So now, when Nicole goes to get a new loan, and the bank pulls up her, and or they ask you to fill out all your debts that have a closing date on it. In other words, you wouldn't put down credit cards. They want to know student loans, car loans, personal loans, things that is a steady payment with a payoff. And so there's a debt to income ratio. They take your monthly gross income and they're only going to allow you X amount percentage of that monthly gross income to be debts. Well, that $1,000 a month is a debt. But if you gave them back $1,000 a month on paper, then that balances it out. So that would go on their income side. And now the new bank can verify that right away. First of all, you can show them the documents. They can go online and see that there's a mortgage recorded. Notes are not recorded, so even if they went online, they wouldn't see it. There are ways you can find out the payment, but they wouldn't. They would see that you're holding a mortgage. And then, of course, the same trust that you're putting down, you're swearing under oath that this is what you owe. You then swear under oath this is what you receive. Income. I get X amount for child support. I get Social Security. I get this. I get a pension, whatever it may be, and I get $1,000 a month from the house I sold. So it's real important that you make sure, because so many times people sell it and then all of a sudden the seller calls them up and said, hey, I can't get a new loan. What are we doing? Now you've created a problem. So they'll appreciate that, because that's one of the things that the attorney may tell them, and that will stop them from selling you the house. If you haven't told them that up front, they're going to say, no, if I do that, I can't buy another home. They're not going to believe you. So cover it up front. Okay, so moving on, some other common objections, and then how you would address them, would be, you want to give them a good feeling, like, hey, we're not like other investors. We care about our sellers. In fact, we're going to ask you for a testimonial. You won't mind doing that. If I do everything that I told you I'll do, will you give us a testimonial? Because that's part of our agreement, that we want testimonials, because, the more testimonials I get, that the next time somebody asks me the same questions you asked me, how do I know you can trust you? Well, take a look what Nicole said. Take a look what Barry said, what Tom said. All these people did that same thing, and we did exactly, we over-delivered, which is always the old saying that under promise and over-deliver, you'll have a much happier client or customer or buyer or whatever position they're in, right? Tell them that you follow the golden rule. What's the golden rule? Do unto others as you want to unto you. So a lot of times I'll use the phraseology where somebody says, well, how do I know I can trust you? Or how do I know you're going to make the payments? Or, how am I going to be protected? And say, listen, you don't know me, and there's, and like in any industry, there's always the bad lawyer jokes and this and that and car salesmen, but there's obviously good car salesmen, there's good attorneys. And there's bad investors and there's good investors. I'm going to treat you no different if you were my family. And if my family or a good friend or somebody called me up, maybe they live in California, I'm in Florida, and they say, hey, Barry, I got an offer on my house to sell. It's something called subject to. What do you think I ought to do? So and they say, how should I protect myself? And I would tell them exactly how to protect myself the same way I'm going to protect you. I do unto others as I want done to me. So that's the golden rule. And then tell them that you believe in a triple win. The triple win, anybody got an idea of what the triple win would be? Who's going to win in this? You always heard, I'm sure you've heard that if you make a deal, it's got to be a win-win situation, like good for the seller, good for the buyer, right? So that would be two of the wins. What would be the third, the triple win? Anybody? And we're really going to cover that on Friday night's class, but that's a hint of what it is. Okay, if nobody knows, well, we're going to put a family, we give a family the opportunity to have the American dream. You know, what we're going to do with your home is I told you that we're going to do cash flow on it. We're not reselling it, but we may resell it on what's something that's called a lease with an option to buy, where we're going to put a tenant buyer in there that can't go to the bank right now. They got good income, they got money saved up. Unfortunately, COVID, messed them up like so many other people. It wasn't their fault. They lost their business, whatever, and their credit's terrible, and so they can't go to the bank. And and they've been renting in this development because their children are in that school system or their parents live there, whatever the reason is that you're going to make that family so happy to move in there. That's the triple win. And that's basically explaining it to them how we make our money, because they're going to say, well, then how are you going to make any money on this? Full disclosure. So if you're telling them this is what we're going to do, I'm going to put another family in there, I'm going to rent the house out, whatever it is you're going to do with it, I'm going to turn it into an assisted living facility to help seniors, whatever your exit strategy is, tell them. There's nothing to hide. So that's how we explain that we're going to make our money. Explain how we use the land trust to protect them with the conditional assignment of the beneficial interest. Hey, Mary, Bob, if I don't pay you, you're going to be able to take that house away from me. Matter of fact, I'm going to do something for you that I don't have to do, but this is going along with how we protect my family. I'm not going to ask you to do any owner financing with me, assuming we're not doing the wraparound, right? If doesn't come into play, now you can use this as really building more trust by telling them this. Say, listen, most investors or people that would say, oh, I'll sign a mortgage back to you. Yeah, but if you sign a mortgage, you get a wraparound, and we're in a mortgage state. And let's say that Nicole's in a mortgage state, like Florida, for example, or New York, or many of the other ones. And I start making the payments. Yes, I've given you teeth into me by signing a mortgage back to you, but that's what bankruptcy is for. And maybe that mortgage that I gave back to you is in an LLC that I can shut down. The problem is I can start making those payments. And if I start making those payments, it can literally take you years. If I'm a smart buyer and I come up with all kinds of motions to delay the foreclosure, we have instances where we have a house for sale now that we're trying to buy. It's been 15 years. Another one's 5 years. The normal time, if the buyer or the borrower, the person that's in foreclosing on, doesn't fight the foreclosure in Florida, yeah, you could go through about 9 to 10 months, maybe 12 at the maximum. But still, you don't want to, this would be saying this to Nicole, you don't want to not collect payments for that. That's a nightmare. You already moved. The whole reason that you wanted me to take this over is because you couldn't afford to make payments on 2 homes. So we're not going to do that. I'm going to give you what's called a conditional assignment of beneficial interest, where you could take the house away because it's personal property, and you could just take it away without having to go through the courts. So you see how you might be able to turn that around to a benefit to really building more trust by explaining to them how easily they can take the house back from you. Of course, it's never going to happen. I'm just a voice over the phone. You don't know me, but I want to protect you. As I told you numerous times, I live by the golden rule. I'm going to protect you no different if I was going to protect mom and dad. And you can see I'm using language to sound not like some big professional, company. I'm talking like an individual, one person to another, mom and dad, using, regular just language. You're having a conversation, and that's how you win these deals. So what are the seller protections? Well, buyer and seller are going to sign a conditional assignment of beneficial interest, where the seller will retain 50% of the beneficial interest as collateral. It doesn't have to be 50%. It could be 10%. We usually use 50. It really makes no difference, because it's going to make it clear that it's just for for collateral purposes only, that they're not getting, and you can write that in there, that they're not participating in the income or any of that. But you're going to explain to them how that's going to protect them, and that the conditional assignment of beneficial interest will state that the trustee will transfer the buyer's beneficial interest to the seller in the event of default. And there'll also be an assignment of any rental income. So most of the time when us investors are buying these subject to, that we're going to rent it out. If you're not going to rent it out, then you obviously wouldn't say that. But if it is a rental, then you'll tell the seller, say, listen, I'm gonna sign an assignment of rental income. I'm gonna make this, so it's never going to happen, but I'm just a voice over the phone. You don't know me, but here's how I'm going to protect you. I'm going to sign this conditional assignment of beneficial interest, where if I don't make the payment by the 15th of the month, right? I'm going to then sell, you then will sell, because you're the seller, and I'm the buyer. If I don't make the payment by the 15th of the month, I want you to send me a 5-day notice to cure, which normally legally you always have to give somebody a chance to cure when they're in default. So you give me a 5-day notice, but we won't foreclose and do something at the end of 5 days because you got to send that certified receipt. So you need a little bit of time for the mailing. You could do email, but you want to do both email and certified. Certified is the best way. So it was then the conditional assignment will say, okay, if the buyer doesn't make the payment by the 15th of the month, the seller will send a notice to cure, a 5-day notice. And if the buyer doesn't make the payment by the 27th of the month, still 3 days before it's late, that you will then instruct the trustee to take their beneficial interest away from them, and or you could then have the trustee take the deed out of the land trust and sign it back to the seller. And also then you'd have the assignment of the rental income. So therefore you won't get the rent anymore. So easily you could take this right away from me. And that's really, if you slowly and you make sure that the seller understands that mouthful that I just said, not saying maybe as fast as I just did, then it's going to give them a comfort level. And like I said, the last part there is I've already said that about the 5 days. So that's what we would do. And it allows them to take the house back, especially this is a strong point to make and explain to them that, listen, we're in a mortgage state and you don't have to get the courts involved to do this. It's no different than if you don't make the payments on your car in the middle of the night, you might be listing your car. So basically to do that, and then we would have a servicing company handling this. Okay, moving forward. Okay, so full disclosure. Okay, let's see what you have to say. So that's what Nicole says. So tell them everything you know about subject to, all the things about it. That it's not a law. You make that very clear to them that it's just a clause in your mortgage, and it says in there that the bank may or may not call the loan due, and that there's a federal law that protects us or you. It's called the Garden St. Germain Depository Act, and that's why we're going to put the property into a land trust, because you have the right to put your property into a land trust. By the way, and if I'm talking to Nicole, so you're selling this house, do you have another home that you're moving into? Yes. Well, then you should probably do the same thing with that. You might want to put that into a land trust so that you still can get your homestead if it's in Florida. That this way it doesn't go through probate. Nobody should leave their home in a will or just leaving it in one name. It's going to go through probate. But if you put it in a land trust, it won't. You can designate who you want in the land trust. You put in there who the successor and beneficiaries are, and it automatically goes to them. Same thing with bank accounts. If you just put somebody else's name on the bank account, there's problems with getting access to that money. So you have to handle it the proper way. So you want to make sure that you're straight and make sure that everybody gets what they were promised, and you tell them that, that you're going to make sure that, if I say I'm going to do something, I'm going to do that and then some. Full disclosure keeps you out of trouble. I told you that before, that if you don't tell them everything, that you'll end up in trouble. Complaints usually result in the investor losing if you go to court. So, and the last one, which is so important, don't make any promises that you won't or can't keep. And that means making that mortgage payment. If you're going to rent this out and your tenant doesn't start paying you, you better be in the position that you can make those payments. If you can't, and I understand there's a lot of people don't, listen, we all start off broke. Not all of us, but sometimes we don't have any money. And obviously doing these creative deals is a way to make money. But you got to be careful. You don't want to make a promise that you can't keep. And the best way around that would be to make that your rental a very strict rental agreement, where as soon as they're late, it's the problem that landlords make. If you're late, if your lease says they're late by the 3rd, if they're not paid by the 3rd, they're late. Then on the 4th, send them a late notice and tell them if it's not paid by the 15th, that you will start a foreclosure proceeding an eviction proceeding against them. So that you give them 3 days notice to cure, then you give them a 5-day notice, and if they don't make it by that, then you have the right to evict them. You cannot, as soon as they call you up and say, listen, and maybe sometimes they'll call you and say, listen, my husband got into a car accident last night, and we came, if you agree, and this is playing hardball, you say, listen, I understand that, but I have a business, I'm sorry, you're gonna have to go borrow the money. As soon as you take one excuse, they'll know they got you. And every time that they're late, it might not be the following month, but they'll always come up with a story, or you'll allow them to go 2 months before you even try to evict them. You have to start off right away being very strict, and you won't have a problem getting the payments. And if they do, then evict them right away, make that monthly payment, kick them out, and the following month rent it to somebody else. But you need to be a stand-up person. So there's a lot of required information, and there's several pieces of important information that you need to collect. Some will come from the seller to make an informed decision about the deal. Like, what is the ARV? Anybody on here not know what ARV stands for? ARV? I would assume everybody does, but that's okay if somebody doesn't.
Rehab.
What does it mean?
After rehab value, after repair value, after repair or rehab.
Right, that after repaired value, that's exactly
Yeah.
what the initials stand for. But we also use that on pretty houses, where a pretty house doesn't need to be renovated. If, let's say, we're taking over a subject to, and like I said before, we have this lead sheet, and obviously that lead sheet, ask, hey, how's the kitchen? How's this? Does the house need any work? What needs fixing? We find all that out, and you find out the house is gorgeous. It doesn't need any work. We still want to find out what the ARV is. So even though we call it after repaired value, ARV also stands for market value, what the pretty houses are selling for in that neighborhood. So you need to establish that so that you know what the value of that house is. How do you know anything is a bargain if you don't know the value, right? When you want to buy a diamond, you want to buy a car, you want to buy antiques, whatever it is you're buying, crypto, anything, you obviously need to know what things are worth. Otherwise, you're just going to pay anything for it? No. So no different when we do real estate, we need to know what the value is. We also need to know the balance on the loan. Because the balance on the loan, knowing the ARV, is going to tell you how much equity is involved, and how much equity involved may determine how you're going to structure the deal. For example, let's say, which something is very popular right now, that most of the deals that we all seem to be working on are ones that are in foreclosure, because it just makes it so easy to get those people to agree to a subject to, because they got no other choice, right? And they're about to lose their home, especially those that are 3, 4, 5 weeks away from the sale date. So the balance on the loan is very important, because let's say they tell you the balance on the loan and you know the ARV, and there's $100,000 spread. Well, they don't really have $100,000 in equity if the foreclosure sale date's 4 weeks away. They don't have enough time to do a traditional. They could get really extremely lucky, and maybe some cash buyer will come along, but the odds are it's not going to happen. And now you speak to them and get some more information, which I'm getting a little ahead of myself, but that's okay. I want to show you why the difference between the ARV and the balance on the loan is so important in structuring what you're going to offer them. So once you find out that, okay, it's $20,000 to bring the loan current. And so now, obviously, that brings really the equity down to maybe 80,000, and it's probably not 80,000, because they may, if they were to sell it, may not get full asking price. But nevertheless, so we realize that we're going to have to offer them some of their equity, cash for keys, something to the seller. We're not going to just take it over and give them nothing. So in that scenario, I think $20,000 would be fair to offer to the seller to induce them to do this for us, right? So now we're up to $40,000 that we would need. And then maybe you're going to keep it, or you're going to assign this and sell this contract to a buy and hold landlord, who will then put all the money up. So now you want a $20,000 assignment fee. So now we know there's 60,000 of the 100,000, but there's still these 40,000 left over that you can advertise to the buy and hold investor, saying, hey, not only are you going to make 15% cash on cash return, and how do we know you're going to make 15% cash on cash return? Because we're going to show them in the ad, this is the mortgage payment, this is what you can rent it for, this is the gross cash flow minus reserves for vacancies and repairs. This is what you're going to net, and that net times 12 months is going to versus the 60,000 that you're laying out plus closing costs is going to give you the 15%. But you're also buying it with a $40,000 built-in equity. So you can see why it's important to know the ARV and the balance on the loan, which gives you tells you how much of that equity there is. We need to know the interest rate on the loan, because that's also going to make it very attractive to your buy and holder, or to yourself, who would not want a 3%, 4% loan for the next 25 years. I mean, come on, of course we would. And of course, then if you advertise, if your exit strategy is not for yourself, and your exit strategy is that you need to make some money quickly, you could make 60,000 a month, 100,000 a month, $10,000 a month, whatever the amount of effort you're going to put in. Now, obviously, if you're full-time on a W-2 job, you don't have that as much time to make calls, but you could then set somebody up on a commission basis or pay them hourly and commission basis to call all these people for you. But nevertheless, you need to do that. And so you need to know the monthly payment, right? Once you know the monthly payment, you'll know if it'll cash flow. So now you would also in the ad, you would put the percentage that they're earning. You'll put all that in there. So got to know that. Then we also need to know, well, we know the monthly payment, whether it includes the interest and taxes. Almost most loans that are new do, but you might have an older loan or a loan where somebody put down like 50% and they only borrowed 50%. Then a lot of times the banks will allow them to pay the taxes and insurance separately. So just confirm that it's a PITI. And then what about if there's any HOA fees and are they paid? Are they paid quarterly? Are they paid yearly? And are they current? Obviously, you want to know if they're current. Well, there's the question, are they current? And then, of course, you would get a bank statement from them is what you would want. So you get them on the phone and this is, and let's say you're calling on somebody that isn't pre-foreclosure. Obviously, you'd have to ask them, say, well, what do you need to bring the loan current? Well, I'm not really sure. Well, can you go get a copy of a bank statement? Do you have that? And when we move forward and we actually are going into contract, that's going to be a requirement that we get a copy of the bank statement because it's going to give you everything you need, the loan number, the bank's name, the address of the bank, the monthly payment. It's going to show you what the arrears are. It's going to show you the escrow amounts that they have in escrow. It's going to tell you everything you need to know about that loan. Okay, do we have any questions? And if not, we could take a 5-minute break if you guys want. We're halfway through it. What time is it? Okay, yeah, we took 1 hour, just perfect. If anybody needs a bathroom break, I'll stay here. I don't need a bathroom break, but we can allow this to be a time for questions. Let people get a drink or go to the bathroom.
Don't you also need to know the rent price in the area?
Yes.
Okay.
Yes, of course you would do that. That would be, yeah. I didn't mention that, but it's a given that obviously yes. And here's a tip: if for those who don't know, write this down. There's a website that's called Rent-O-Meter. So you spent it just the way it says, rent, R-E-N-T-O, right, meter, and .com. And what you do is you put in the address of the home that you want to buy, and put in what you want to rent it for. And it'll tell you, it'll actually have like a Geiger counter, like a needle, and it'll either be in the green, yellow, red. If it's in the red, you're on the high side, and it'll tell you what percentile, and it'll also give you comps. It'll actually tell you what all the other houses in the vicinity are renting for, and there'll be a map that'll come along with that, and you can click on them and see which each one's renting for. So that's how you would tell it. But here's an interesting thing, depending on what your exit strategy is, and we're going to talk about this on Friday night, that if you're doing a lease with an option to buy, if that's your exit strategy, because we don't like being a plain landlord. I'd rather do lease with options to buy because we pass on the maintenance and repairs to the tenant buyer, and we call them a tenant buyer. That's a slang after the first 30 days. We're not going to hook them up for 30 days, make them move in and 2 days later the air conditioning breaks. No, we give them 30 days. So we'd rather do a lease with an option to buy. And generally you could get anywhere from $300 to $500 more than the going rental. So if the rental in that neighborhood is $1,500, I can get $2,000 from a tenant buyer because their philosophy, their mindset is buying, not renting. Now, if they give you grief and they say, well, wait a minute, yeah, the rental in this neighborhood is $1,500 a month. Why are you getting $2,000? And that's like a real stumbling point for them, even though I'm giving you the opportunity to buy. I say, look, I'll tell you what I'll do. How about I give you a $300 credit? So if you pay me the $2,000 for every month that and it could be the whole 500, whatever amount you want. I'm trying to make a little extra, but it could be the 500. Say, hey, I'll give you a $500 credit, which is all they're doing is just giving you an advance on your profit if they do close. If they never close, then you just got $2,000 a month, and most of them do not close. Most of them will either move sometime during the 3 years. They get a job transfer or a divorce or whatever, or they just never fix their credit, and they've been making the payments to you on time. So many different reasons why they don't go through, and then you get to keep all that money. And if it's the same tenant, many times you can let them redo another 3 years, raise the rent, collect another non-refundable deposit. So yes, but in answer to your question, you definitely need to know what it rents for, or you wouldn't know whether or not you could show that spread that I said before, of the return on your investment, the cash flow. Anybody else have any questions?
Yeah, Barry, can you? Sorry, go on, Max.
Go ahead. Go ahead.
So I just wanted to ask about the lease option side of things there. I know you mentioned this before, that you do that because you don't want to have to foreclose on them and you can just evict them instead, and that's much easier, and there's some other benefits as well. Can you talk about the equitable interest portion that could get you into trouble there when doing lease options, if they paid a fee that goes towards the property, if they're responsible for repairs and they've made updates to it, and also just like them paying money towards the principal as well? Like, doesn't that then count as equitable interest and then makes it much more difficult to evict them at that point?
No, not at all. And okay, so you've probably heard some problems with lease options. And lease options, the biggest problem would be if you use a lease, one document, and let's say clause 17, you put in there, tenant has the option to buy this house and puts up a $20,000 non-refundable option fee. So now you go to evict them for non-payment of rent, and they bring you into court and they say, but Your Honor, we're buying this house. Why am I being evicted? What do you mean you're buying this house? Yeah, we gave them a $15,000 down payment. And of course, your attorney's going to get up and say, no, Your Honor, that's they've signed, they acknowledge that it's a lease, and that's a non-refundable option fee that will give them credit if they buy the house. But if they don't, they walk away from it because we took the house off the market for 3 years. No matter what you tell them, there's more chance that the judge will lean towards believing them, and they might dismiss the eviction court case. And now you say to the judge, but well, Your Honor, if you're not allowing me to evict them, how do I get them out of the house? And you say, well, you're going to have to evict them. You're going to have to take them to foreclosure court because they've got some kind of equitable interest in the home. So then the solution that other educators came up with is do two separate agreements. One is the lease option. One is the regular lease, and one is the option for the option to buy, and they're two separate documents. So the lease never mentions the word option anywhere in it, and the only difference to that lease versus a standard lease is that we put in there that tenant is responsible for maintenance and repairs after the first 30 days. The option agreement mentions the lease and says that, yes, we acknowledge a $15,000 non-refundable option fee, and as long as you're not in the violation of the lease, which you mentioned in the lease, that you've signed dated so and so and so, that you can get. If you're not, you'll be evicted and you walk away from your money. Even with that, since it's the same signer, you sign the lease and you sign the option agreement, you go to evict them and they say the same thing, Your Honor, we're buying this house, and they come up with the same excuses, and you're going to lose. So the safest way and the way to beat that problem is putting it into a land trust. When it's in a land trust, you have the trustee sign the lease, or a management company for the trustee. But if you have the trustee sign it, right, and then you have the beneficiary sign the option agreement, so it's two separate parties and signed on different dates. So now you go into court for eviction, and probably with an attorney, because if a trustee signs the lease, then a trustee cannot represent themselves in court, because they're really not representing themselves, they're representing somebody else, and that's acting as an attorney. You can't do that. If the trustee was yourself, then you could, but if you're a trustee for somebody else, no. So now the attorney gets up there and says, Your Honor, there's nothing in that option, in that lease, that talks about anything about an option. And then they bring up and say, yeah, why have this other option agreement over here? And then the attorney says, can I see that? And then looks at it and says, Your Honor, that's a different party. That this party has nothing to do with that. And there's no way that the judge can rule on the other party. They would have to turn around and tell the tenant, you're going to have to bring another lawsuit against them for that, but you're getting evicted. So that's how you handle that, Paul.
Okay, I think all that makes sense. And just one quick follow-up on that as well. You mentioned that after 30 days that they are responsible for all repairs. Isn't that illegal? Like, don't you, as a landlord, don't you have to make sure a property is habitable? So if they break things while they're there, they have to repair what they've broken. But in terms of water heater breaks or a roof leaks or anything like that, is that not a landlord's responsibility?
Okay, you're mixing two things. There is the habitability laws. Like if somebody doesn't pay the rent to you, and you shut the water off to their house, you're in trouble. If you shut down the heat, maybe it's gas or oil somehow that you have control of that, you're in trouble. If there's air conditioning in the house, no air conditioning does not have to be fixed. So if you're renting a house and the AC breaks, and usually the tenant's going to say, and we've had this happen, oh, I'm going to call my attorney, I'm going to call the town, and you can't. No, AC is not required to make the house habitable. But if it doesn't have a habitable kitchen, then you really can't sell that house. You can't get traditional financing, but we're doing a lease. And you can do, now there are certain states that may have a requirement that says that you can't put repairs onto the tenant. But most don't, because you can go around it in the legal paperwork that you're giving them.
Okay, all right, good to know. Thanks a lot.
Alex, you have a question?
Yes, I do. So, Barry, you said if you're doing subject to, you would ask them, will you sell for what you owe? But with the lease option, you say what now?
Okay, so a lease option is different. Are you asking me on an exit side or a buying side?
Well, I think you was mentioning earlier, you said if it's subject to, you say, hey, as a person calling the seller, will you sell the property for what you owe? That's what you said.
That's subject to.
Exactly. For lease option, what do you say?
Okay, so we're gonna go over that Friday night, but I'll answer that for you right now. So basically, let's say you went through, you join our group and you have this lead sheet that I've been telling you about that has the 3 questions on there. And it says on there, if they have more than 15% equity, let's say they're asking $100,000 and you find out they owe 50,000. Do you think that you should say to them, will you sell for what you owe?
No.
What are they gonna do if you do that?
No way.
They're gonna hang up on you, right?
Yeah.
Now you became one of those bad investors, just want to steal my 50,000 in equity, right?
Yeah.
So obviously that option is not there. And that's why we tell you if it's more than 15%, then you go to option question B. And question B, I'm going to give you your answer now, states this. Mary, if we can agree on a purchase price and we would close when you wanted to, would you, and if we were to take over all maintenance and future repairs, would you sell your house on a lease option?
Okay. Got it.
That's how and we're going to go over that in detail on Friday night. Are you going to be on tomorrow on Friday nights?
Yes.
Okay, so that answers your question. It's a totally different question. It's a different buying strategy. And of the 3, I told you there's only 3 ways: subject to, lease options, owner financing. Of those 3, which one don't you get the deed? 2 you get the deed, 1 you don't.
Lease option.
Yes, lease option, because you're only leasing it. You didn't buy it, right?
Yeah.
But if you do subject to, we're getting the deed, right?
Right.
If you're doing an owner financing, the proper way, not a contract for deed, but if you're doing owner financing, the bank is the seller is just acting as the bank. They're getting a mortgage. You get the deed. So I'd always rather get the deed than not, because there are some problems, but I've also got the solution to that. And that question wasn't asked of me. So now you've been doing this for 3 years and you're a tenant buyer, fixed their credit, got an approval letter from the bank, their bank ready to close. They contact you and say, hey, Barry, we're ready to close. And now you go and you contact your seller because you don't have a purchase agreement with them yet. And even if you did, it's not valid if it's 3 years later. So, and now you can't find them. What do you do now? Or they died, or they got divorced and they say, I ain't signing nothing. Or they didn't, you can reach them, they didn't get divorced, they didn't die. And they say, you can pound sand if I ain't selling you that house for the price. We know that house is worth $100,000 more because the market went crazy in the 3 years that you took it over and it doubled in price, where it went up 50% more. They're going to say, hey, I agreed to sell it to you for 200,000. I want 250 or I want 225. You don't like that? Take me to court. So that's why it's better to get the deed than do a lease option on the buying side. On the selling side, the only way Eric and I will ever sell is with a lease option.
Yes.
Because we don't have to foreclose. And yes, we don't have to foreclose if I do the selling on the assignment of the beneficial interest, because I can do the conditional assignment, but I'm killing the golden goose. And I'm not going to talk about that right now. The benefits that you give up, that's for Friday night.
Yes.
Any other further questions?
Hey Barry, I have a question.
Yes.
Why give the seller 50% partnership, I guess?
You don't have to. You know, I said that before, you could be 1%. Just need them to be a beneficiary. So whenever, so that the seller is a beneficiary, the buyer is a beneficiary, you already got the trustee, and all three parties sign that conditional assignment of beneficial interest. So they've both agreed that if the buyer doesn't pay, the seller is going to do X. And the only way that the seller has that control is if they're a beneficiary to tell, because who tells the trustee what to do? The beneficiaries do. But both beneficiaries have signed that document agreeing that this is what the trustee is to do.
Okay, is there a sweet spot of an interest?
It makes no
that
difference. It's just for
percentage
collateral. It
you
makes no
give them?
difference. It makes no
Okay.
difference. It probably makes the seller feel more comfortable if you tell them they're getting 50%, right?
Yeah, would they have any
Fair,
right
fair,
to
50-50.
50%?
In their brains, you know, regardless, it doesn't matter. They're not, it's for collateral only, for security purposes. It's also going to state in the conditional assignment of beneficial interest, when you do that, it's going to state that when the loan is paid off, that the trustee will remove the 50%, 10%, whatever the seller has, because they don't keep it forever. It's gone as soon as the loan is paid off.
So it just in their mind feels that makes them feel fuzzy, but they don't have control of
Yes.
nothing.
No,
Thank you.
you're welcome. Anybody else? All right, so I believe everybody should be back from their break. Let's continue on. So let's go into now items that we need from the seller. The communication from the bank will be, you know, well, we want. I'm getting ahead of myself. So, okay, so let's pop up the things that we're going to need, and then I'll explain that. Okay, so the first thing you're going to need is a limited power of attorney. It's called a doable power of attorney. What that means is, and it's only a power of attorney to deal with that house, not to deal with their stocks or anything else in that person's life. It will say, it'll spell that out in the power of attorney that you have power of attorney to deal with that property. If your seller gives you that and they get hurt and they get in a car crash and they're in a coma, is that power of attorney still valid? What do you think? Yes or no? Anybody? We'll put it in the chat. Yes or no? What's the feelings on that? You got a power of attorney. The person who gave it to you was in a coma.
Yes, as long as they're alive, right?
Exactly. As long as they're alive, that power of attorney is good. What happens when they're not alive anymore and they pass away?
That power of attorney, it goes away. It's null and void.
That's correct. Okay, so we need the power of attorney so that, and the main there's a lot of different reasons, but the main reason that that's always been incorporated is because people are afraid and they do the weak side and they name the seller as additionally insured. And I'm dealing with a major problem right now, a $90,000 insurance claim in 3 different payments where they have the power of attorney, but they want they really screwed up. I think they did something illegal, but they want the seller to sign the checks. I said, "Don't you have power of attorney?" They want to sign a form that says and certify it that they, as the owner, are assigning the beneficial because that's an assignment. I said, "No, they're not the seller anymore. They're not the owner anymore. And you're asking them to sign this document to assign it to you. That's fraud. You're the owner. We're not signing it." So, but that's the reason. So if you get an insurance check and you've put down that the seller is additionally insured, when we get the insurance, we're going to say the trustee is the insured, bank is the first mortgagee, and then most people put the sellers as additionally insured. If you did that, and now you get an insurance check, you don't want to give that to them because they may cash it and not give it to you. And matter of fact, if you Google, this is a true story, if you Google, how do you insure a subject to, I guarantee you, you will find that it comes up right away, usually, a case where the insurance company made a mistake and they issued the check only in the seller's name. And it was a $1.2 million check. It was on a commercial building that burnt down. And they got that check, they cashed it, and they fled the country. And nobody's ever seen them since. Now the bank is out all that money. The bank got a burnt down house, a property that's worth nothing. So, but that would have never happened if those people had never put the sellers to be additionally insured. So whoever's on that insurance policy is named, their name will be on that check. So if it's the insured, obviously will be on the check. The bank will be on the check because they're the first mortgagee. And if you've named the sellers as additionally insured, their name's going to be on that. But if you have the power of attorney, then you sign that check. But again, as I asked before, what happens if they die? What happens if you have this claim after they die? And now you can't cash that check. That's a problem. So I don't like putting the sellers on as additionally insured for that reason. But that's the reason the biggest reason for the power of attorney. We also want a notarized letter to the bank authorizing the bank to communicate with you as property manager, not as their property manager. Make that very clear, because then it's fraud. But you are going to be the property manager, are you not? You buy it, you're going to manage it. So there, and some of you may have seen this already. There's forms going around. Do not use a standard form, because that just shows, now could a lawyer, that if you went to a lawyer, if this was actually a homeowner that was legitimately, doing estate planning, would they give a notarized letter to the trustee saying that they should be able to speak with you, or a trustee or somebody that's managing for them, perhaps, and then maybe it would be a standard form. I like to make it look like it's a homeowner, so therefore you type up a letter it's not a standard form, it's just a letter, addressing to the bank, loan number, reason for it, and you put in there that I, Barry Sandhouse, hereby give, Bank of America authorization to communicate with Bob Jones as the property manager. You can contact Bob Jones at this phone number, this email, as long as the email doesn't sound like it's, if it's just bobjones@gmail.com, great. But if it's Bob Jones at, Home Investors, no, I'm not giving them the email. I'm just going to give them their phone number. And to say that, that he's authorized to speak with you. So you need to have that done, because otherwise you can't communicate with the bank. But there's something further we want to do. And that's this here. It's so important to have, most banks have online where you can manage the loan online. So if they do, what you're going to want to do is get into that and change the username, change the password. So you want the username to be your name, not the seller's anymore. You want your email, not theirs. You want your cell phone number, not theirs. And then you want to check something that says paperless statements. Because especially if you're renting the house out, you don't want anything going to the rental. And so what other people are doing in TCs and other title companies across the United States that just are not as astute as Eric and I are, and they're saying, oh, here's a standard form to send to the bank so that you can have it. No, it's not going to work. They're going to know it's going to look phony. But here's the problem. You usually can't change the username without having the social security number. You could change many other things on there, but not the username. So there's a couple of different ways you do it. Either in the contract, we put that the seller is to change the username to this name, and they're to change it to this password. And so they go in and do it for you, and then you change the password, and you could also so that they can't get back into it. We don't want them back in. And if you do the paperless statements, you don't have to worry about anything, because most people do a change of address. A change of address is a red flag. Why sure, somebody, you're allowed to rent your house out, and the loan can't be called due. So in that particular case, if your letter to the bank was on the notarized letter was we're moving out of their house, we've put it into a land trust, we've hired there's a property manager that will be renting the home, then that might be different, because then you're letting them know that you're renting the house. And so at that point, then you could say, and from now on, any bills or correspondence, at the end of the year, the 1098 for how much taxes, how much interest you paid, send it to this address, because I won't be living in the house anymore because I'm renting it. You could do it that way too, but it's got to be a letter, not a standard form. So then we're going to change the contact info, including the phone number. I've already told you that, and the email to you. And then we're going to do the paperless statement. So go ahead and take a photo of that, because those are the things that you need. Okay, moving on. General procedure. Well, the general procedure is it's best, but first we're going to set up a land trust, right? So we take title on a land trust. What you should do is when you sign the contract, you have to put down who the buyer is. You can't put down the name of the trust to be the buyer, because unless you are the trustee. If you've already preset that up, and let's say you've already opened up a Wyoming LLC ahead of time, then yes, you could sign under that LLC's name and say that here's the buyer, Trustee Services or whatever, or National Asset Protection Group is the buyer, and you could sign because you're the member of that LLC. But most of the time, the way you should do it is your name, and right after your name, put the wording "with a newly formed land trust." I want you to also then add into the contract someplace or an addendum that seller acknowledges buyer to take title in a land trust. The name of the land trust is 125 Main Street, Smith Land Trust, assuming I'm buying Mr. Smith's home, who lives at 125 Main Street. You just made that contract assignable, and now there's no way that they can deny that you're taking title in a land trust. And the reason it's assignable is because the trust document and the benefit and who the beneficiaries are, if there's an assignment of beneficial interest, is a private document nobody knows. So nobody would know that you've assigned it. So we're going to and at that point you could sign the contract by selling it like most wholesalers, and then your buyer would be taking title in the land trust. Your seller did not know who the beneficiaries are because all you did was your name. You didn't say that you're also going to become the beneficiary. You could allow them to assume that, but you didn't tell them that. Makes no difference. It's none of their business because they're never going to know unless we do the assignment of beneficial interest. But that will be once we close. So that's okay. So that makes it. So we set up the title and we take title in a land trust. We name the trust the seller's address and name, 125 Oaks Jones Land Trust. If we're buying Mr. Jones's property at 125 Oak Street, right? Then at that point, we nominate a trustee, could be a person or an entity. So it could be the seller's name, who can be the trustee. I said that we're going to get into some different things on that. And I think there's some more slides coming up on that, but it can be the owner. It could be an attorney, or as we've been telling you, mostly we've been doing, especially if you plan on buying a bunch of them, then I think it makes sense to open up a Wyoming LLC and name that LLC that sounds like a fiduciary and have that be the trustee because you're in control. And that way you don't have to spend, especially, listen, it's not very hard to have 100 rental properties, that are in land trust. And then you'd have to pay every year, you have to pay 100 different fees. That's a lot of money that you could save, even though it's 100 per property, but still it's overall to totally, you're paying all that money, having 100 homes in land trust and having to pay $100 for each one of them or $200 for each one of them. So it'd be much better to have your own trustee service so you don't have to pay anybody to do it. So now we're going to record the deed. Then the deed gets recorded with the trustee's name in front of it. So if the trustee's name was Trustee Service Group, LLC, then the deed would read Land Trust Service Group, LLC, as the trustee of the 125 Oak Street Jones Land Trust. That's exactly the wording that will be on the deed. The only name on that deed is the trustee. If I was going to be the trustee, I'm selling my house or I'm buying my house, buying a house, and I wanted to be the trustee, then it would be Barry Sandhouse as trustee of, and it could be my own house, of the 125 Main Street, Oak Street Sandhouse Land Trust. Doesn't make a difference. So whoever's name is going to be on it. That's how it gets recorded. So at closing, then what will happen is there'll be a trust document that's signed by the seller. The seller will show that they owe 100% of the beneficial interest in that land trust. It'll only be signed by the seller, who's now is the beneficiary, and the trustee, which would hopefully be you as the member of the LLC. If you're married, so now you have two people that can sign, or if you have a partner, let one partner sign as the trustee, the other person signs as the beneficial interest, or maybe it was the person's name on the contract, so that the seller doesn't realize that the trustee that's signing for it is really the same person. So at the closing, the reason that there's two reasons why that when we do the first document shows that the seller owns 100% of the beneficial interest in it. First of all, the reason we do that is that becomes a non-taxable transfer. There's no transfer tax due because the trustee that's the deed's being recorded in isn't paying Mr. Jones anything for that property. Mr. Jones is just deeding it to the Trustee Service Group, LLC, to be the new owner of the property. No consideration. So anytime there's no consideration on a transfer of a deed, then obviously you can't ask for a transfer tax because there's no price. It also then allows you to keep the taxes not to increase the following year. The second reason we do it, so that one has to do with saving recording documents, recording taxes, as well as stopping the taxes from going up the following year because the tax assessor assumes it's the same person owning it, that Mr. Jones still owns it, and therefore he just put it into a land trust to avoid probate. The second reason we do it is if the bank was, or if you're going with my new procedure where I say, let's tell the bank first and get the seller, let's get Mr. Jones, and we'll write the letter for Mr. Jones and have Mr. Jones send a letter off to Bank of America, if that's who's holding the loan, and asking for permission to put it into the 125 Oak Street Jones Land Trust. And we will actually form the trust, have it notarized and everything. We don't change the deed, but we form the trust document so we can attach that with the letter to the bank saying attached is the trust. We need your blessings or whatever we need to do to move forward. If we don't hear from you, maybe give them 14 days, give them 7 days, whatever you want. That we'll assume that there's no problem. We'll move forward, putting it into a land trust. What do we need to do to move forward that we have your blessing, that you acknowledge that we're doing this? So I'd rather do it that way, but if not, then of course, if not, then, and you didn't do it that way, and all of a sudden, if the bank was to find out, and all of a sudden, Mr. Jones, a month or 2 or 3, gets a letter saying, hey, or it could be at tax time, because that's the first time the bank finds out the land was transferred is when you send a new insurance policy. If that didn't trigger it then the second time would be if you were buying a house now, then November of 2026, the taxes are going to change and the bank's going to get a new tax bill, but it's not going to be in Mr. Jones's name anymore. It's going to be under Trustee Services Group LLC is going to be the name on the tax deed. On the tax bill. And now the bank says, hey, what's going on? Now the bank writes a letter to Mr. Jones and says, hey, we see that you transferred your deed into our land trust and you never got our permission. You didn't get our, we didn't tell you to go ahead and do that. Even though they know legally they can't stop you, they just, in the mortgage that you signed, it says that you're supposed to get their permission. So then at that point, then if they might say, let us see the trust, or if they don't say the trust, they just say, you need to rectify this. You could then write them back a letter and say, and include the copy of the trust, say, look, here's the trust document. Now, if the letter to Mr. Jones from the bank that says, hey, we see you transferred your property into a land trust, we'd like to see the trust. And by the way, did you sell any of the beneficial interest? Now you got a problem because you don't want Mr. Jones to lie for you and say, no, I didn't transfer it. Because if they find out, and there's ways they can find out, but if they did, now you just had Mr. Jones commit bank fraud. So that's why I prefer to get it up front permission, so you never have to put Mr. Jones in that position, and you'll sleep well at night knowing the loan will never be called due. Because once the bank approves that it's going into the Land Trustee Services Group LLC as the trustee of the 125 Oak Street Jones Land Trust, then they expect to see that come through. The insurance will be in that. There's no reason for them unless somebody screws up and you don't make the payments, or you screw up the insurance, or the seller decides to rat on you, or somebody else rats on you. That's the only way that they would call the loan due. But if nobody does any of that, there's no reason for that bank to ever have a red flag that you've already told them up front. Makes sense,
Barry,
right?
got a
Yes,
question,
sir.
Barry.
Yeah, we got a quick question in the chat. Manny's got a question for you.
Okay.
Yeah, Barry. This reminds me of a deal that I couldn't do due to Medicaid. The seller was worried that if he sold the property, Medicaid would find out that he got a large sum or there was a sale happening, and they would take him and his wife off Medicaid, so he didn't ever sell the property. And it sounds like he was going to get stuck with it till he dies. Would this protect them the way that you're doing it now? If that makes any sense?
I'm not telling anybody to commit any fraud or anything like that, but certainly one could, what I would do is I would first contact Medicare or whoever and say, we're putting putting them on notice, same that we put the bank on notice. We're putting our house into estate planning purposes. I'm not very, my health, I'm getting up in ages, and to avoid probate, we're putting the house into a land trust. And now you'd be able to send the copy of the trust document to Medicare or Medicaid, whatever one it is, and show that, yeah, that seller owns that Mr. Jones still owns 100% of the beneficial interest and he did not sell it.
Okay, and then if he owed no money on it, I would just have to buy it as a seller finance? Is that how it would work?
Well, we'd still put it into, yes, whether there's 100% equity or 50% equity or 25% equity, we can do a hybrid where the seller allows you to finance that as well as taking over the loan. Or if there is no loan and it's free and clear, then yes, then they're holding the mortgage for you, but it's still in a land trust. And
But
no,
you
it doesn't
cannot,
have to be in a land, it
but
doesn't have to be in a land trust, but you're better off, when we buy things for cash, I think I've said this numerous times, we still put it in a land trust. If we're buying a house for cash and there's no bank loan on it, then I'm just gonna name it the 125 Oak Street. I'm not gonna put Jones on it.
oh, so I could still pay it out cash and he still get the money?
You could pay cash and put it in a land trust. You could, and at that point, if you did it that way and you're paying cash and there was no loan on it, then you would have the grantor grant it right to you. You would become the beneficiary of putting it in, or it could be done the same way. It makes no difference. But yeah, there would be
But
no.
his Medicaid, but his
Excuse me?
Medicaid would it trigger the Medicaid if you did it in a cash purchase?
Oh, well, now you're asking me, no, again, it makes this, that's part two. Part A is, I thought you were asking me a different question. But if you're combining it with the Medicaid that buying a house and it was free and clear, no, again, they're not gonna know because you're gonna buy the beneficial interest. And how much you pay for that and whether they hold a mortgage for that, nobody knows. All we're gonna do is send, if that house was free and clear and you're gonna buy it for cash, but you're buying the beneficial interest for cash, you're not buying the property. You're buying the beneficial interest. We're gonna transfer it into the 125 Main Oak Street Jones Land Trust. And Mr. Jones is the one that's going into a nursing home, and he's gonna send that trust document off to Medicaid to show that he's the beneficiary. The other side of the equation where you pay him for the beneficial interest, which is an assignment, is a private document, not recorded engineers.
Genius, thank you. Thank
Okay.
you.
Okay, so number 7 on here, I think that was the last one I brought up, right? At closing, the sign ourselves a conditional. Okay, so at the closing, we had the trust document number 5, right? Then, which we just talked about a few different times. Then number 6, which we mentioned, but now there'll be the second document where the seller signs a conditional or a regular assignment if you're not giving any recourse back to them, right? And sometimes you don't. Maybe if they have terrible credit, they don't plan on buying another house, whatever. You could, maybe they're in jail and we've bought them in jail. You don't need to do a conditional assignment. Just have them assign it to you, right? So either way, at the closing, there's a second document that the seller now as the beneficiary now assigns their 100% over to your LLC as the new beneficiary, and that does not get sent to the bank. It doesn't go anywhere. Then the seller, as mentioned before, can assign 100% of the beneficial interest to your LLC as the new beneficiary. So that's what happens. Any questions on the procedure? Okay, let's go into a couple of scenarios. So detailed purchase procedure. Now that there's a trustee and a beneficiary or multiple beneficiaries, if you're buying this with a partner, right, for Mr. Jones, then it could be Manny and Barry, and the beneficiaries could be your LLC and my LLC, or it could be us individually, but we'd only do that if we were in Florida. We wouldn't do that in another state because then we're putting ourselves liable personally, so we wouldn't do that. So there's a lot of different scenarios that would play out. So we want to find out. So let's say you are doing it with 2 partners, right? Well, who's going to have the power of direction? Who is going to control the trustee? Or maybe you have 10, maybe you've raised like a fund and you got 10 different investors that are putting up money to buy this property. Maybe it's $1 million property and you're going to do a big Airbnb or you're going to make an assisted living facility out of it. And, it's going to make a lot of money. And that's why you raised a bunch of money and you got 10 beneficiaries. Well, who is going to talk? Somebody has to have the power of direction over the trustee, like the management, right? So a couple of different ways that you can do it. So scenario 1, seller assigns your LLC as beneficiary. The trustee is either your LLC or an attorney that you've hired so that you can control it, right? So either way. Scenario 2, seller becomes the trustee and includes a director with full power over the beneficiary. Seller retains beneficial interest. If you do it that way and you got caught, right? You didn't ask the bank permission up front, they could never call that loan due because the seller could sign something saying that I still own 100% of the beneficial interest, and they're not lying. They could send a document to them, the trust document. There wouldn't be any assignment because they never assigned the beneficial interest. So the seller is the trustee, can be, or the seller you could have a different person be the trustee, but the seller retains 100% of the beneficial interest. You control it because you're a director with full power over the beneficiaries. So that's another way that you could do it. and then you could direct all the payments to go to your management company, so that as the director, you have the right to go ahead and lease the property out or do whatever you want with it because you're in control. But from a legal standpoint, the seller has the beneficial interest, and you have control over it. But then, of course, you would have other documents that state that, you know, if you owe them money, or if you didn't owe them any money, that they would no longer be have the beneficial interest once the loan is paid off, or once you finish paying them their interest, you know, if they left you some money behind, some equity. So, you know, every deal is different, but these are just different ways that you could create these things. A hybrid of the scenarios of 1 and 2, seller assigns the beneficial interest, and seller is the trustee, but they resign from the position of trustee at closing. Now, I learned this from Clint Coons. Some of you may know who Clint Coons is. He's with the Anderson Group. They are probably the top asset protection lawyers in the United States, and they're like a one-stop. They do accounting, they do your accounting, they do asset protection, they do estate planning. So they do all three. A lot of times you have different individuals doing that, and one doesn't talk to another. And then you have a regular attorney who's not really an asset protection attorney, and he didn't really tell you the right way to do things. So there's a lot of different ways of doing it. So the way Clinton was doing it is, if you had him set up a land trust for you, he will show his name as the trustee. So when the deed gets recorded, it would say Clint Coons, attorney at law, as the trustee of the 125 Oak Street Jones Land Trust. And then at closing, he resigns. So, but we go ahead and then well, I'm getting ahead of myself. Before he resigns, it would be the same things. There'd be the assignment of the beneficial interest. So the sellers, or we first have the trust document. The trust document shows that the seller is the trustee and owns 100% of the beneficial interest, and there's an assignment of the beneficial interest to you, but he stays as the trustee. Now that you are, this is all happening at the closing. We haven't left the closing, what I'm explaining to you. So now at the closing, in order, right? So now he signed the beneficial interest over to you, so you're now the beneficiary. So now beneficiary controls the trust, right? The trustee is the owner. Well, you as the beneficiary control who's the trustee. You can fire a trustee at any time. The question has been asked, what happens if the trustee passes away? The trust document itself will cover this. It will say, in the event that the trustee dies or you fire them, you could actually list in the trust document who the successor trustee will be, just like you can list who the successor beneficiaries will be. So what happens is now is at the closing, the trustee, which is the seller, we're going to go ahead and record the deed as Bob Jones as the trustee of the 125 Jones Land Trust, but you have the beneficial interest. But now the deed gets recorded that way. So when we send the insurance in, the bank is never going to call that loan due because it was Bob Jones first, and now it's Bob Jones as the trustee of his own land trust. And so, but he also resigns at the closing, signs a resignation form. And before he resigns, you have him sign what's called a trustee's deed. So that, because if you record the deed with his name on it as the trustee, who owns the property when a property is deeded? Isn't it the name that's on the deed? Well, the only person that can sell that property or transfer it, if you haven't started to sell that property out of the trust, your buyer doesn't want the beneficial interest, they just want to buy it and they want to put it in their name. Well, who can sign that deed? The only person that can sign it is the trustee, but the trustee just resigned, and maybe they move or they pass away in the time, but they're no longer the trustee. That's why you get a deed pre-signed. It's called a trustee's deed, and you file that away in your file cabinet so that when you do go to sell it, you've already got a pre-signed document. Now, questions may be coming up. There may be a question already jumping ahead in the chat. What happens to protect yourself? How do you stop the seller from going down to the courthouse and stealing that house from you because they're the trustee, right? The property appraiser office doesn't know they resign. As far as they know, they're the only name on the deed. So obviously they could sign a new deed and sell the property to somebody. Well, that would be a fraudulent. If that happens, that what you're going to do is part of our agreement is that you're going to get the seller to agree that you have the right to file a memorandum of real estate. So you're going to cloud the title somewhat, and you have to have the seller's permission, and it's notarized by the seller, and you record it that you have an interest in that property. and that you have a beneficial interest in it. So now the seller tries to screw you and, is going to sell it. The buyer's going to get title insurance, and the title company all of a sudden is going to send you an email, or if they have your phone number, call you or both and say, hey, we're selling this property and we need a release from you because we see that some reason you had claims against it. Can you sign this release? Oh, no. Let me tell you something, Mary. If you sign that deed and you issue a deed to this buyer, you're going to be issuing a fraudulent deed. And that's not going to look very good on your part. You didn't do your due diligence. I've got a signed resignation form from the seller that he's no longer the trustee. I have the assignment of beneficial interest where he has signed it. So he doesn't own beneficial interest and he's no longer the trustee. And I have a signed deed from him that he signed it 2 years ago, a year ago, whatever time frame, or last week, whatever. So that's how you stop that. Questions? That's got to bring up some questions.
Nothing in the chat at the moment. So
Really?
you guys open up your mics.
What? No questions?
There's nothing in the chat at the moment, but you guys can open your mics if you have a question.
Now, the question that I would ask if I was sitting in your seat and I'd be asking me, well, how do you handle the insurance? So is the insurance going to go in and say Bob Jones is the insured? And then what happens when Bob Jones now is not the insured? Of course, you could go with Bob Jones and then having the power of attorney so that if a check comes and it gets sent to you because you changed the address and all the rest of that garbage, then yeah, you could cash the check. But better that you have the insurance state that the insured is the trustee. The present, that you get the insurance company to agree that the insured is the present trustee, because trustees change. And technically, you would probably want to change the deed, but you don't really have to. You can record that there's a new trustee, a memorandum with the courthouse. You don't actually have to redeed it. So that's what I would do. That would be the question I would have asked. Let's move forward.
There's a good question in the chat now.
Okay.
How do you handle the lender if they do call the loan due?
In which scenario?
Kaleem, you want to open up your mic and
I'm going to go
explain?
back. In which scenario?
Well, he's just saying
Yes, Barry. So if there's a loan due on it, right? And if you're buying a property with the financing on it, and you're at, that's the scenario I have in my mind.
Well, every property, if we're doing a subject to, every one of them, that is. But that's not giving me enough information. Is it with the is it where, okay, scenario one, you have the beneficial interest and the trustee is your LLC, not the seller, and you didn't get permission from the bank to get permission to put it into that land trust. That's one scenario, and my answer to that would be, which I already gave, would be that you would then send the trust document, and that's why we put it into the seller's name first, and hope that the bank didn't ask if they just sold the beneficial interest or not. If the loan got called due and they did ask, did you sell the beneficial interest? Then what I would do before you answer that is I'd have the buyer assign the beneficial interest back to the seller with a side note saying that they really don't own it. You can cover that. And so now the seller could answer and say, no, I still own 100% of the beneficial interest. That'd be one way of doing it. Other people teach, and there's a couple of different scenarios. If they call the loan due, you certainly could pay the loan off. You could refinance it. You could sell it. Or you could deed it back to the seller's name, take it out of the land trust, deed it back to the seller. And people are saying then do either a lease with an option to buy or do a contract for deed. So you would change it around many different ways. If it was scenario two, seller becomes the trustee, then if they're not going to call the loan due because the seller owns it and the seller retained the beneficial interest. And even if we didn't ask for permission, then if they said, hey, we see you transferred the deed into a land trust without a permission. Yeah, that's right. Exactly. I did that. And I'm the trustee and I own the beneficial interest. What are you going to do about it? I have the legal federal right to do that. There's nothing they can do. So I think that answers your question. Unless you give me a different scenario that you want me to answer. Another question, Eric?
Yes. If you are the trustee as a solo owner of a Wyoming LLC and you die, and you are also a sole beneficiary as the Wyoming LLC, what will happen? How will you control this? With a will or with a other trust?
No, what we put into the trust, if you're an individual, and it does happen, and you have no relatives, you have no brothers, no sisters, no parents, no children, you don't plan on getting married, you're 70 years old or 65 years old or 55, whatever, and you're going to be a bachelor or a lady that doesn't get married, bachelorette, then maybe you don't care if you die who gets the property. That's kind of like dying intestate where you have no will. Who are you leaving it to? Maybe you want to leave it to the church. So we always put in the trust document has a spot in there for successor trustees. It says if trustee passes away, so and so you list maybe two or three. You can list two or three trustees and say if the first alternative trustee is not available or doesn't want to, then you go to the second one. And that could either be your children, if you did have children, it could be your spouse, it could be your sister, it could be whoever you want it to be. So that's how we handle that.
Does that answer your question, Carlos? He follows up with, I assume beneficiary keeps the beneficial interest document. What if they get lost?
The buyer keeps the beneficial interest and says if he loses that document.
Correct.
Well, since it wasn't recorded anywhere, although it does have to be signed by the seller, but you obviously with today, we put things on computers. You print it. You could have a hard file, which is what I would do. I'd have a hard file of everything and put it away in my file cabinet. I'd have it on a thumb drive because I back up all of our stuff or an outside hard drive or up in the cloud. But there's ways that if you're doing business, because things do happen, burn down, the house burns down, and you lose everything. Well, did you have things already backed up on the cloud? So there's different ways to handling that. Any other questions?
Nope.
Okay. Okay, so let's go with this one here. So seller assigns your LLC as the beneficiary. The trustee is either your LLC or an attorney that you've hired, right? Buyer's name on the contract can be you or a newly formed land trust. It should say with a newly formed land trust, but you can say newly formed or with a newly formed land trust, either way. But I prefer to might as well just make it really clear. With a newly formed, telling that you're going to do it, and then I like to go on and say the name of the trust will be blah blah blah. And I told you before that I would state that the seller acknowledges that buyer has taken title in the land trust and name the title. So take title in the land trust, name as the seller's address, and name 125 Jones Land Trust. Form a Wyoming LLC to be the trustee. Use a Wyoming LLC to open up a second LLC in your state that will act as the beneficiary. It doesn't have to be in your state, but you might as well do it in your state. And then the seller is required items that we discussed that you have to get from them. And then you close, right? So basically that's it. Now we talked about the next thing that I'm going to come up with. Any questions on this procedure that we have right here? And that's the standard procedure. Buyer's name is going to be you with a newly formed land trust. You're going to take title in the land trust, name the seller as the seller's address and name, like 125 Oak Street, the Wyoming LLC. Why the Wyoming LLC versus an LLC someplace else? Well, first of all, if you were to use an LLC someplace else, even if you made the LLC Asset Protection Group, that sounds like a fiduciary, but you filed it on Sunbiz in Florida and you formed it. Now the bank says, okay, let me go to Sunbiz in Florida or whatever state you're in to go to the corporation webpage and put in that LLC and let me see who owns it. And now they come up with Barry Sandhouse owns this Wyoming LLC. Now they just Google my name. You Google my name. There's tons of stuff on the internet that tells you that I'm a real estate investor. Put my name in Facebook. I'm a real estate investor. They got you. But when you go to Wyoming and you try to do that, and you go to the Wyoming State corporation webpage, they don't even ask who the member is. So Wyoming can't tell anybody because they don't know. They don't ask. So that's why we go to Wyoming. Get the seller required items. We just all that. Okay. So moving on to the secret sauce. Power of direction is the secret weapon. The director of your land trust holds all power over the trustee. We talked about this. So unlike many other types of trust, the trustee of a land trust cannot act without a specific direction in writing from the person or entity that holds the power of direction. So normally If it's just a trustee and one beneficiary and nothing else, that beneficiary automatically has the power of direction because that'll be in the trust document. Remember I said before, what is a trust document? It spells out the powers and responsibilities of the trustee, powers and responsibilities of the beneficiary. And in there, it'll state that they have the power of direction over the trustee. So beneficiary names you as the director of the trust with an amendment to the trust, a separate document which the bank doesn't see, which is also signed at closing with power of direction. And as the director of the trust, you now have total control over the trust. We talked about this before, where you could have your name not show up on any of it and let the bank think that the seller did this all, but yet you have total control. So the trustee must take directions from the director, even if the beneficiary doesn't agree with any of the decisions the director makes. You're in total control because of the document that you had the beneficiary, which was the owner, sign, giving you total power. And it will state all that in there. The director can be you, a corporation, or an LLC, a partnership, or any other trust. It doesn't make a difference who the director is. More than likely it'll probably be an LLC because you do, as I mentioned yesterday, you should be operating as an LLC and very little ever on anything in your own personal name. Scenario number 2, seller retains the beneficial interest. Seller becomes the trustee, includes a director with full power over beneficiaries. So buyer's name on the contract could still be yours with a newly formed land trust. Take title in the land trust. Seller's name as the seller's address. Nothing changes there. Seller does not assign the beneficial interest. They retain it this time. Seller is named as the trustee. Seller as the beneficiary nominates your LLC as the director with full control. And you file the memorandum of real estate that I told you to protect yourself, right? And then you close. So that's how you would do that scenario. Third scenario, hybrid of options 1 and 2. Seller resigns from the position of the trustee at the closing. Oh, and let me go back to, I was starting to tell you about Clint Coons, how he does that. And so what happens when Clint Coon does that, and then he resigns and signs the trustee's deed at the closing, so you've got a pre-signed document. And the way he tells the story is, perhaps maybe a year or two down the line, or sometime down the line, he gets a phone call from an attorney and says, I'm reaching out to you because you're the trustee of the so-and-so land trust, and we're looking to file a claim with the tenant who lives in there got hurt. Can you tell me where I should send any of this? Oh, no, sorry, I'm no longer the trustee. I resigned from that 6 months ago, 5 years ago, whatever. Oh, I didn't know that because they never changed the deed and they don't have to. Then, of course, the other attorney, the opposing attorney is going to ask Clint Coons and say, well, can you tell me who the new trustee is or who the beneficiary are? No, sorry, I can't tell you. That's client privilege, client attorney privilege. I can't release that. So that was why he felt that was cool. So then I took that and said, hey, we could also do that with the seller being the trustee and do the same thing. And that way you wouldn't have the problem with the bank calling the loan due and handling the insurance, because that's usually where they get you. So buyer's name on the contract, same thing, that doesn't change, would be you with a newly formed land trust. The way we take title would be the same. We name it after the address and the last name of the seller. Seller is named as the trustee and the deed is recorded with the seller's name as the trustee. We form the Wyoming LLC to be the trustee, then the Wyoming LLC to open up a second LLC in your state to be the beneficiary for all of your land trusts. Then at closing, seller resigns by signing the trustee resignation form. At closing, the seller signs a trustee's deed, which you hold on to. At closing, the seller, which is the current beneficiary, nominates your Wyoming LLC as the new trustee. So this way, the bank sees the seller's name on the deed, and that way, well, let's say seller's name is trustee. Yes, you form a Wyoming one. They don't know that because that's going to be hidden. You don't have to then do a new deed and record the one that the seller signed over to you. You're holding that in your filing cabinet that shows that the Wyoming LLC now has the deed. And then at closing, seller assigns 100% of the beneficial to your LLC, set as you become the beneficiary, and then you would definitely want to file the memorandum of real estate, and you got to get the seller's permission to do that. So you have them, that would be in the contract to purchase, that you spell all that out, that they're going to have to do that. Any questions?
We don't have a question, but we have a
Can
statement.
you go back to slide 1?
All the way to the very first slide?
No,
Oh,
scenario number 1.
one.
Oh, scenario 1. What happened to scenario 1?
I'm going back.
Oh, there it is. Okay.
And also,
Thank
Barry,
you.
if you can stop at the scenario 2 and 3 again, just the
Oh,
final
okay. So
ones.
you guys could take snapshots of it. Okay, fine.
Correct. Yep.
Okay, cool. All right, guys, everybody done taking a picture of that one? Should be by this
Yeah.
point. Okay, let's find number 2. Whoops, get it all loaded first. There's number 2.
One more, keep going.
Okay, well, oh, there's one more? All right, you got to close, right? Why isn't it moving forward? There we go, close. Okay, now I'll move on to 3.
I have a question on 3.
Okay,
So how do you protect yourself from the trust if the seller becomes a trustee and it's before he resigns? Is there any issues with somebody not signing off on that in their?
now this is all done at the closing. So if they refuse to close it, there's no closing. They lose their house or whatever problem they had.
Okay. Right.
This, because of, remember, this is all going to be in the contract, that we're going to tell the seller that they're going to be doing all these things. We don't just spring it on them.
And number 3, when you said Wyoming LLC open a second LLC on your state, open a second is only like get the registration of the Wyoming as a foreign entity, or
You don't want to use the Wyoming LLC that's going to be the trustee to also be the beneficiary. So that's why you need you can have another Wyoming LLC be the beneficiary if you want. But generally it's better maybe to do it in the state you're in, especially if you're investing in the state that you're in, and then you'd have that. Now, the beneficiary really doesn't make a difference where that's formed. You can form it in any state you want, even if you don't live there. It makes no difference because it's doing nothing but owning the beneficial interest. It's not renting, it's not doing business, it's holding. There's no business. But who signs the lease? That LLC, whoever signs the lease, either has to be, if the LLC is not formed in that state that you're doing the rental in. What state are you in, sir?
Florida.
Okay, so if you're doing, because I can't see who's speaking, that's,
Carlos.
I call. So if you have rentals in Florida and you had a Wyoming LLC to be your general checking account one, then you would have to file the Wyoming LLC to do business in Florida. Or you'd have a Florida LLC that's owned by the Wyoming LLC that could then be the management company to collect the funds. So whoever's collecting the funds and signing the lease, they have to be registered to do business in the state. You can't do that with an out-of-state LLC. You can if you take the out-of-state LLC and register to do business in Florida, then that out-of-state LLC can write a lease, collect money, and do all those things. That answer your question?
Well, I get a little confused then. Then you have one LLC or Wyoming LLC for your trustee, okay? Then I will get a second one to be the beneficiary, and I will have another one, Florida LLC, to do the management. It'd be fine.
Correct. And all 3 of them the owners of them should not be you, should be the Wyoming one. So if anything happens, let's say the management one. So the management one's the one's going to get sued, right?
Yeah.
So if somebody falls in the house, they're going to sue the trustee, because that's the name on the deed, and they're going to sue the management company who signed the lease with them, right?
Yes.
Okay, so when they do that, they're going to want to then find out who the owners are. Well, if the Florida one is owned by a Wyoming LLC, they're at a dead end because they're going to go to Florida's Sunbiz to see who owns the Florida LLC that signed the lease. And it says member it has a name of a Wyoming LLC. So now that they go to Wyoming's corporation webpage and they put in the name of the LLC, they find it, but nowhere's on it does it tell them who the beneficiaries are. I mean, who the members are.
Okay.
That's why we do it. It's just making things harder.
Yeah, they will see the Florida one because in here you need to put who is the
landlord, correct?
Yeah, and who is when you do the registration of the LLC, you put who is the representative.
No, you don't do that. If you're going to open up a Florida LLC, just like the Wyoming, when we have you open up a Wyoming LLC, you never want to go to the corporate website in any state, even if you have somebody, if you're going to rent, let's say, they have these like UPS or post office boxes where you can rent an address at a physical address. So let's say you got that covered. And then you got somebody, a brother-in-law that lives in a different state than where you're dealing, and you name them as going to be the registered agent. But you're the one filling out the form. Your name is going to be as the what's the word they use? The organizer. You will be called the organizer. So now your name is attached to it. So when you fill out and you form a Wyoming LLC or a Florida LLC, you do not do that. You hire a company. If you go to Wyoming LLC attorneys.com, right? So if you see over here, I said Wyoming LLC, instead of to be a trustee, if you put in Wyoming LLC attorney.com, that company it's an attorney firm out in Wyoming, and they will form it for you for $99 or $199. And for that price, that includes the state filing fee, their fee, and then you pay them a monthly fee. So they will be your registered agent. They will supply the mailing address and the physical address.
Than they do for Florida.
And they can, and then I'm almost positive that if you want them to open up a Florida LLC using Wyoming LLC, they'll do that for you too.
Thank you so much.
Does that company also open up like I'm Canadian, so a C Corp and a limited partnership for you?
Well, they may be able to do that. I don't know because I'm just going to the LLCs, but I know when you're Canadian that there's a problem with being double taxation. And the only way that I found around the double taxation for Canadian residents is that you have to have which you said correctly on the second part, is you have to have a U.S. limited partnership. And you become the limited partner, and therefore there's no double taxation.
That is correct. So, but you know what, a funny story, on the first week of me setting up all my corporations with an attorney out of, and it's all Wyoming, because of the name that I chose, a lawyer called me and said, hey, you got my clients' names. And he gave me a list of all my companies. And I'm like, oh man. But I told him, like, we're not in the same business. So really, you got nothing to worry about. He left me alone. But yeah, I was surprised he found all 6 entities at one shot.
Wyoming?
Yeah, my C Corp is Wyoming. My limited partnership
so your
is
name,
Wyoming.
so you formed them yourself?
No, I paid an attorney to do it. Of course.
Oh, you paid an attorney, but he put you down as a member.
He put me down. Yeah, he put me down as a managing member or something like that. Yeah.
Somehow because Wyoming doesn't know who the members are, so something's not making sense. That attorney did something that he shouldn't have done to allow your name to be found, because your name should not be associated. Even Wyoming doesn't know who the members are.
Well,
they'll know
I don't know if it's on the C Corp.
They'll know who the organizer is.
Maybe it's not on the C Corp, but I'm a managing partner on my LLCs and all that stuff. So I guess he just followed the trail.
Yeah, he did something wrong.
Okay, all right. I can't reverse that at this point.
Right.
But,
well, you can. You can redo everything.
Oh, do it all new. Oh, I did have one question, and I think it's relevant to this subject. If it's okay. So I am selling a property out of Texas. I'm doing seller financing for the buyer because I sold him another property and he doesn't have money to pay the second property. How would I protect myself on a seller finance? And can you help put the contract together?
I can do the contract, and I would transfer it into a land trust and sell him the beneficial interest with the conditional assignment of beneficial interest, everything that I've taught you. And yes, I can do all of those for you.
Okay, because
give me a call tomorrow or something. We can talk during the day, okay?
Okay, sounds good. Thank you. Appreciate it.
You're welcome. Listen, guys, it's already past 9:30. We have 7 more slides to go through. So let me get through this unless there's some really important questions right now. Because I know some people keep drop off and can't stay on as late. But nevertheless, let's see. So let me get back to where we were. Oh, okay. So we went through that. So now we're at setting up the insurance. Was there any other questions that I didn't get a chance to answer, Eric?
No, not at the moment. Alex had her hand raised, but she put it down, so she's gonna wait.
Okay, good. All right, so required items. You need a landlord's policy, not a homeowner's policy. If you're taking title in a land trust, the only way you can get a homeowner's policy, and that's something that you work out with the insurance company, is if you're moving into it. If it's going to be your home itself, then you'd want to be the beneficiary in your own personal name. And I don't worry about if you're in Florida, you have nothing to worry about. But if you're in another state, I still do your name as the beneficiary because what's the odds? You know, everybody has their own house in their own name, and you're not worried about being sued if somebody falling on your property. You got general liability insurance. But when you have a rental, you have no idea the horseplay and the craziness that are going on, and therefore you wouldn't want to be responsible for any lawsuits. But it's very rare that ever be a lawsuit against somebody suing you because they got hurt on your own property. So if you then you'd want a homeowner's policy, even though the loan is the deed is in the trustee's name. That would be convincing the insurance company to do that. If not, then it needs to be a landlord's policy because the first thing when there's a claim, what the insurance companies do, their fiduciary responsibility is not to you as the insured, it's to their stockholders, and that means that they have to sign up as many premiums as possible and deny as many claims as possible. So the first thing an insurance company does is they go to the property appraiser's office and they see, does the named insured match the deed? If it doesn't, that you just gave them a loophole to deny the claim. The second type is, what type of policy do you have? So if you're not living in the house, but you have a homeowner's policy, which is what so many people are led by the wrong people. There's a lot of bad information that you think that they know what they're talking about, and they tell you to leave the homeowner's policy in place and add your name as additionally, put your LLC as additionally insured. Well, you're not covered because now when the claim comes in, the deed is in your LLC or your trust name, and your name is additionally insured on a homeowner's policy. And so for 2 reasons. One, it's a rental because now somebody got hurt and they find out, they say, well, who is this John Smith? His name is on the deed. So who's John Smith? They're gonna find, oh, he was renting. Oh, you were renting, but you have a homeowner's policy? Wrong type of policy? Denied. In that particular case, it would also be denied because also wasn't the person on the deed. But let's assume that it was on the deed and you took out the wrong type of policy. Even if it's not a subject to, you own a piece of property that you bought that you were going to do a renovation on, and somebody gets hurt while you're doing the renovation, and if you don't, or the building burns down or something, and they find out you were doing work, if you didn't have an all-risk builder's policy, they're not going to cover it. If you just took out a homeowner's policy because you're going to move into it, but you have to renovate it first, you better get an all-risk builder's policy. If you bought a house, and whether you buy a subject to or however you bought it, and you're leaving it vacant because you want to put it up for sale, then you better have a vacant home policy. If you have a house that you're going to rent it, you need to have a homeowner's policy. If you're going to live in it, you have to have a landlord's policy. If you're going to live in it, it would be a homeowner's policy. So the type of policy, if it doesn't match the scenario, that's the second reason that the insurance company can turn you down. So the insured is the trustee because we're teaching buying everything in a land trust, and the owner of a land trust is who? The trustee. So that's why they're the insured, right? Then the bank is named as first mortgagee. I have a liability insurance naming the beneficiary and the seller. The reason you do that is that the scenario I just gave you of somebody slipping and falling on the property. When you take out a hazard policy, the hazard policy will be against fire, wind damage, water damage, things of that nature. But it'll also have a general liability policy, but it's only naming the trustee. It's protecting the property. They don't know, who the beneficiary is. There's no legal connection to that they're aware of. So now, and the same thing with the seller. The seller's got nothing to do with it. The only connection that the seller has is their names on the mortgage. If it was your son or your husband or whatever, and the two of you were renting a house and your husband becomes paralyzed, becomes a quadriplegic, and that was your only income, you're in a really bad situation. That's a nightmare. Your attorney's going to sue everyone. They're going to name everyone. They're going to find out who the beneficiary is. They're going to force the court to tell, the trustee disclose who the beneficiary is, and they're gonna name everyone. They're gonna name the beneficiary, they're gonna name the seller, they're gonna name the trustee. Everybody's gonna be named in that lawsuit. Doesn't mean that they'll win against the beneficiary or the seller, certainly against the seller. They may win it against the beneficiary, especially if you name the beneficiary your own person and you're in a state that you don't get any protection. Like I said, only Florida does. So anybody can be sued, but now in order to defend themselves, they got to hire an attorney. But if you name them on a general liability insurance, the beneficiary or the seller would get legal representation for free, because that's what a general liability policy does for you. Otherwise, they probably would have to lay out a minimum of $5,000 to $10,000 right up front for a retainer to get an attorney started, and then it'll be $300 to $400 an hour. And then once you deplete, or you get real close to depleting the 3,000 or 4,000 or 5,000 you gave them, they'll ask you for more. It could go up to $40,000 before that lawsuit ends, and it probably would take that long. Why would you want to be involved with that? So that's why you need to, and nobody teaches that. Very few do. Is there anybody on here other than hearing it from me or Eric ever heard of that before? I would assume that nobody's going to say yes, because it's not taught by anybody. Okay, was that a question? Or was that just somebody talking background?
That was just background noise.
Okay, all right, so then you're gonna have the liability policies, I just said. Then you do not leave the seller's insurance in place. You do not want to have two policies. Most policies have a clause in there that's called an excess clause. An excess clause states something along it's kind of similar to how an umbrella policy works, where an umbrella policy only kicks in after the first policy pays, and then whatever it doesn't pay, you have $1 million, you have a $2 million judgment against you, and you only have $1 million first regular, general liability policy. So that policy pays the million. You then, your umbrella policy would pick up the second million. Well, it's kind of similar in the excess policy. What they say is they point fingers. They say, "Oh no, we'll only pay if the other insurance company pays." So now they both companies find out that there's two policies. They point fingers at each other, and neither one of them is going to step up and make the payment. You, as the owner, are going to have to take them to court. So you don't want two policies in place. That's a weak spot. That's when people don't have the knowledge and the comfort that I'm teaching you guys. And so it's taught by people that don't know what they're doing. They're thinking like an investor. And I keep telling you, think like a homeowner. And so what they'll tell you is leave the homeowner's policy in place, get your own policy, and never tell the bank. But at least your policies, so take title in an LLC, get a policy that protects the LLC so your investment's protected. And unfortunately, the only negative to that is if they find out the excess policy, and second, aren't you paying for two policies? Why would you want to do that? That's the weak way of doing it. No, we don't do that. If there's no online access, follow up with a call to the bank after the letter telling them that you're the property manager is sent, and the power of attorney, and then they'll tell you where to send the new insurance policy and things of that nature. Because if there's on access, you can then usually upload the insurance information through that. When you do take the insurance out, you will give the insurance agent the policy name, the name of the bank, and the address of the bank. I'm saying the loan number, the address of the bank, the name of the bank, and have them send the bill to them. And so that way they'll know, and then you, as the power of attorney, and you can also get either a separate form that's that's authorized, notarized by them to the insurance company, telling the insurance company that they've given this insurance company permission to speak to you, so you can cancel their homeowner's policy. Only the seller or you, as the power of attorney, can cancel that. The bank isn't going to cancel that. They can't. It's not their policy. So that's how you handle that. If it's online, a lot of times you can just upload it, but if not, then you call them. So you give the bank the loan information, the borrower's name, and the address of the home. And then ask the bank where to send the new insurance. That's pretty simple. It's just common sense, really. Power of attorney. Okay, so gives you the limited power of attorney, POAs. When you see that, that's what it's abbreviated for. You use the POA for dealing with anything to do with that house. But as I mentioned before, warning, that a PLA is worthless after the seller dies. So having a PLA does you no good if the seller dies before you receive the insurance check. Many people do this incorrectly because they don't know how to change it without getting the attention of the bank, which we just spoke about. And then if you do endorse that check after the seller passes away, that is both bank fraud and insurance fraud. The seller does not own the property anymore, therefore should not be on the policy, right? Any questions so far? Now I'm going to give you some actual examples. All right.
Sorry, before you move on, Barry,
Yes.
you just mentioned, would that apply if the seller died and was sued, let's say the day after in the general liability? The liability part as opposed to just a normal, house burns down situation.
I'm not sure if I understand your question. Are you saying that the seller passes, it burns down, and the next day the seller passes away?
Yeah, and then, or no, if they're sued for a slip and fall, you said
Right.
that the power of attorney only applies when they're alive.
Correct.
So would the fact that they passed away means that they cannot be sued anymore,
No,
or what?
no, because almost all contracts always say that this is binding on heirs and successors. So if that person died, they have a wife, they have children, they're still on the hook for that mortgage.
Yeah, okay.
And I've taken over two houses where the seller passed away as subject to. So yeah, it happens.
Gotcha. But then the power of attorney would no longer
Be valid.
be.
That's why I don't
be-
want them to be additionally insured.
But you did mention
General
that in the
liability is
general.
different. You asked me about the general liability.
Yeah,
But
correct.
general
Is that a
liability doesn't
is that a
matter whether they're
separate
alive or
policy?
dead. No, that's
Is
the
that a
same policy, but that part of the policy, that declaration page doesn't get sent to the bank.
Okay, gotcha.
When you
All
take
right.
it out, because you are going to have general liability insurance, and then you're going to tell who you want it named, but we put the naming of your beneficiary, your LLC, and the seller's name on a separate document, a separate declaration page, that if you work with our insurance company that we recommend with Ann Cook, then that's how she'll do it.
Okay. All right. I've sent you an email because I might need to catch up because obviously we just settled a property on Friday, so I'll need to perhaps just work through a few little bits and pieces on that, but we'll take that offline.
Okay, and like I said, you could call me tomorrow if you want, and you had a few other questions for me.
Yeah, I sent you an email. We'll book in a time.
Okay, all right,
Good.
so here's a summary example. So a foreclosure auction date is 3 weeks away. Owner's out of time, right? The address is 1901 Hall Avenue in Spring Valley. It's a 4-bedroom, 3-bath with 2,500 square feet. You found out that the ARV is 450. The PITI is 2150. Mortgage balance is 360, and you know that you can rent that for $3,000. And to make the loan current is 15,745. So this is all the information you found out so far, right? So what do you do? So you know that you can rent it for 3,000. The PIT, so that gives you a gross cash flow of 850 a month. But you should realize, some of you might not realize, that you're not supposed to count. Yes, it's going in your bank account, but you'll get caught short if you don't set things up for certainly commercial properties. It's always done that way. You need reserves because you eventually will have a vacancy and might miss that 1 month, right? So then it's not 850 cash flow, and then sometimes you got to go repair something. So for repairs, so let's call it net of $700 a month. $700 a month times 12 months is $8,400 a year. That's your net, or what we call NOI, net operating income, or your cash return. So far, everybody good so far? There's no questions. There shouldn't be, but there might be. Let's go a little further. So cash needed, right, is going to be 15,745 to bring the loan current. We're going to offer $15,000 to the seller cash for keys because we have a $90,000 spread here, don't we? So there's quite a bit of equity there. And so we offer them 15,000 cash for keys. And there happened to be an agent involved. And if there's only 4 weeks left, we're going to tell that agent, especially you might have found this through an agent, and that's one of the things that we definitely recommend is call as many agents as you can and say, hey, I'm sure you've got some listings, because they do, especially if it's a pretty house. And the auction's 4 weeks away and you're out of time. They might have had it for 3 or 4 months or whatever, and they just, for some reason, they're asking too much, whatever the reason is, it's not selling. right? And the market slowed down anyway. And you said, look, if you come across those, we can usually save that deal. We may not be able to pay you your full commission, but you'll definitely get something. So the agent is better off to accept the 5,000 than getting nothing in 4 weeks, right? So most of the time you can work that out. That's all negotiable. So you're going to need 35,745 to close, which would be the amount to loan to bring it current, what you're going to give cash to the keys and to the agent. All right. So if that's what you're going to plus closing costs, if you're bringing in 8,400 a year, right? How you find out what your return on your investment is, you divide the larger number into the smaller number. So you divide the 35,745 into the 8,400, and your calculator will show 0.234, which is 23.4% return on investment. That's a great investment. So I don't think it's on, no, but I could have added another variation to this. I'm not sure if it's coming up on the next scenario. What if you wanted to assign this? Right? So, you don't have the 35. There's two scenarios. You don't have the 35,745. Two scenarios for you. One is you had a $20,000 assignment fee, and now the buyer has to come up with 55,000. Well, we have to divide 55,000 into 8,400 and see if it's still attractive to our buyer. So I'll do that for you now. So I'll put 8,400 in. Whoops, there's too many zeros. 8,400 divided by, what did I say? If there was another 20, would be 5,575. So that would be still a 15% return on the investment. So you'd be able to write an ad and maybe place it on. There's about that I know of at least 15 different sub-2 groups all over the country, and they all have Facebook groups. So join those groups, place an ad on there, hot subject to deal, dollar signs on the side of it, capitals and hot subject to deal. And then I would put, did it give us the interest rate on this one? Well, it didn't tell us the interest rate. But let's say it was 3.75%. So you'd put underneath that low interest rate, 3.75% underneath that in capitals, right? And then you can put, exclamation points on either side, like highlighting it. Then underneath that, I'm going to write 15.7%, whatever it was, 15% return on your investment. And they're also getting equity, because if they're spending 55,000 and there's 90,000, they're still getting equity. I'd put that in there, and then I'd actually write and show them down below. Then I'd go into the description. I'd go into the description that we have up here, not the foreclosure, but I put in, 4-bedroom, 3-bath with 2,500 square feet, and if it had a pool or whatever else, I was going to describe it. It's on a cul-de-sac, gated development, whatever it is, describe it. And then below that, I'm going to put the math. And I'm going to show this stuff over here. That I'm going to show that the PITI is this. I'll write it actually this way. I'll write rental rate, PIT. I'll draw a line underneath it, put a subtraction, just like I have the subtraction there. I'll show the 850, then I'll draw a line underneath that, right? And I'll underneath the 150, and I'll show reserve. I'll show net. So basically, I'll do this right in the ad, and then I'll show them that if you divide their 55,000 by the 84, that's how they're getting their 15%. And if this was 4 weeks away, then within 4 weeks, you're getting $20,000. That's one way. What if you don't want to sell it and you don't have the $35,000? How about you borrow the 35,745 from a Gator? On Pace's Facebook group, he's created something called Gator Lenders. You don't have to get it from Pace's group, but that was pretty creative of him to do that. But there's plenty of people that will take a second mortgage and lend you that money. Now, as long as then what you would do is you would figure out, okay, so I'll do it for you right now. So I would take the 35,000. No, it would be, yes, 35. So let's round it off to, let's say 40,000 that you borrow from them. Maybe you need, you need closing costs, and maybe there's 1 or 2 small items. Maybe you got to replace some carpeting, whatever, something you want to do. So I'm going to divide the 40,000 times the 40,000 times, let's say 8%. Maybe you found somebody that's got money sitting in an IRA, in a Roth IRA, and they're like 42 years old or whatever, and they can't touch that money until they're 59 and a half. So it's just going to sit there. So they might as well make it click at 8%. So that's $3,200 a year. You divide that by 12. That's only $266. So I would take the 266 plus the 2,150, or subtract the 266 from the 700, and still positive cash flows that you now own it, and you're going to get the mortgage pay down, right? As long as you hold on to it, you're going to get the depreciation, you're going to get the appreciation. So yeah, it's a good deal for you. So you can buy this whether you have the 35,000 or not. let's move on to another scenario. Okay, so consider the same Hall Avenue house as an option. I may be telling you the other things here. Okay, so yes, it is. All right, so we're going to show the 15,000 to seller, the 5 to the agent, the 15,000 to bring current. So we know we have to bring that to close. Then to close plus this 20,000 assignment fee that I just told you about. So this would be the entrance fee for an investor. Right? I didn't realize that I had this all spelled out. I've already just verbally told you this. But there is one more spot on here, and then you can take a picture of this. So there would be the 55,745 divided by that, which I just did. I didn't realize I had it already. And you keep the 20,000 assignment fee. Please take a photo of that. I just showed you how you could quickly make $20,000 within the next 3 to 4 weeks. There isn't anybody on here that can't do that. You just go to the clerk of the court, find a county that you want to work in, find the foreclosure calendar, go out 4 weeks. It'll tell you the names of it'll give you the docket names of the case numbers. You can then click on that. It'll bring you to it. You can find out who they are. You contact them and you make this deal. Simple, isn't it? I mean, that's the best information I feel I've given to everybody tonight. And out of the 3 nights is this right here, because that's the low hanging fruit that will disappear. Because right now there's a ton of these that are in foreclosure that are the low interest rate that makes this work because they're low interest rate loans. If they were high interest rate loans, they wouldn't cash flow because you can't change the rental amount, but we certainly can buy and change what we pay to own that house. Okay, moving on. All right, so review. At this point, in the course, you should have a general understanding of the trust, what it is, why it's much better than an LLC, why it's important, and the key parts of a trust. It's important because we know we don't want to raise a red flag to the bank when we're doing a subject to. You should have a general understanding of what subject to is. And after today's session, you should also understand general approach to speaking to the seller, items required for making the purchase to the deal, the overall subject to procedure, and the 3 scenarios that you could be prepared for to deal with, and the important items related to the insurance. Questions? Any questions? Any part that we spoke about tonight or the first 2 parts?
You guys can open up your mics. You don't have to put it in the chat.
Yeah, just the recording. Are there going to be recordings? Because this is a lot.
Yes,
Okay, you take
on
over.
the Patreon website that I shared the last 2 nights, and I'll share it again here shortly. The recordings will be available on there.
Okay. Yeah, please share it.
All right, so I'll do that now.
Hey there, Mr. Barry.
Yes.
You are rocking, man. Thank you very much.
Thank you, Jay. Where do you live, Jay?
I'm in Dallas.
Dallas. Cool. We do a lot of business in Texas.
Yeah, this is the most straightforward, and I really appreciate. I'm one of those guys that I flipped and had to jump ship back in 08, 09. So I had a little bit of a run, which was nice. But a lot of acquaintances of mine, in the industry, they, for some way, some reason, somehow, several of them were, federally fined, indicted, and in prison. Even for just simply being the agent on the loan and not the appraiser. So, I've been around the block, several years ago. However, with the way that things are going, I mean, in real estate, you can make money. There's 1,000 ways to make money. And I've always been interested in making money in a down, so-called industry time frame with real estate. And I've never really been able to execute. So the way that you've laid this out, it's a lot to process. But when you write down the steps and then you reconsider it a couple of times, it'll all fall into place as far as the overall puzzle. So I just wanted to thank you, man. Great information.
I appreciate that, Jay. And Eric's about to talk to you about our JV partnership program. Were you on last night or the first night, Jay?
Last night I was. The last 2 nights I've been out in public, and I didn't have my camera on, so no disrespect about that. But yeah, I was there last night. Absolutely.
Well, I think that everyone who hasn't done their first deal or has not really scaling their business up and really could use a hand up, but certainly for those who haven't done their first deal, it's a no-brainer that you should definitely join our partnership program because you're going to get your first deal done and you're going to learn about it, because everything that I talked to you about tonight, if you were in our JV partnership program and you said, Barry, can we do a one-on-one class, a Zoom? I do that with you because you're my partner. So you get the free education, and we do more than just subject twos. We do commercial, we do land development. Tomorrow night, we belong to the Orlando sub-2 group, and tomorrow night they are bringing in a land developer. Well, Eric and I have done land development with a partner of ours. They made over $250,000. In other words, we took 7.5 acres, got an entitlement on it, which means we got 14 lots out of it. So we do more than that. We do fix and flip, which up on the screen right now, you can see me. That's me with the hat on in the back of you on a Saturday where we're actually at a house that needs fixing and flipping. I'm an ex-builder. I built over 200 homes. I was third generation in the plumbing industry. So, and even if you're not doing fix and flips, there's certain things that you better know when you buy a house as a rental that will hurt you or could really get you in trouble, where there would be a negligence, a fire, because of the electrical problems in the house that you might not be aware of. So we do a lot more. So it makes sense to me, since we give you back your deposit out of the first deal, and then it's free forever. And I appreciate you telling me that you appreciate my knowledge. Oh my God, I could go on for weeks and not repeat anything I would teach you. That's how much information 44 years that I have. So we help everybody, and each one of the people who come into our partnership, they're not all working. We have some that are just working on mobile homes, parks. We have people that are working on self-storage facilities. We have people just doing subject to. We got people doing lease options. I help you on anything you want to do. Overages, there's a ton of different ways, as you said, to make business money in the real estate business. And the cool part is that you pick and choose. I'm taking away Eric's thunder, but you pick and choose what deals you want to do with us. But for those who haven't done the first deal, instead of losing money on your first deal and then never coming back in, please join our partnership program. And now, for the price of the entrance, especially because you get it back for free, you would have to spend $100,000 without exaggeration to have the same education that Eric and I have in all the different asset classes that are out there.
Well, I know that there are entities out there assisting individuals in acquiring different trusts, not irrevocable trusts or revocable trusts. Those are really the only ones that I know about, and then land trusts, of course. But there are individuals that are charging upwards of $10,000 to, develop and establish and write up a trust. So I work with a young lady down in Florida, and she's helped me establish irrevocable trusts, but they're private trusts, so they're not registered with, the county or, like an LLC.
No trust is. Why would you do an irrevocable trust? It means you can never change it. You plan on keeping that property forever?
Well, no. This is in regards to not just properties, for example, but even vehicles. So, like, for example, I just purchased a vehicle in a trust, and it's owned by the trust, and I can operate it.
That's a personal property trust is what that is, but it shouldn't be an irrevocable.
Sure. Are
you sure it's irrevocable? Do you understand what irrevocable means?
I do. You can't change it, and so
you have no control over it. You cannot say what needs to be done. Once the rules are set up, that's the rules. That's the rules.
Right. Well, that's the only rule that I want.
Is what? So what if you want to sell that vehicle?
As the trustee can sell it. Yeah, the trustee
only if that's written into the trust agreement that the trustee has the power to sell the car or the truck.
The trustees have the power to buy and sell.
It's got to state that in there. It's got that clear.
Obviously, it is. It's spelled out.
Yeah, it's got to be spelled out. Irrevocable trust is really, the irrevocable trust is more of an asset protection to put things into that you just don't want anyone. You see,
all right, it's 10
everybody
o'clock.
else know. Yeah, okay, we'll talk about it some other time.
We're going to talk about this on Saturday.
Okay,
that'll be
Barry,
Saturday.
I'm in. Barry, I'm in. So you'll be hearing from me after the weekend's class. Sorry about that taking so long.
Thank you, Jay.
I'm in.
Okay. It's okay.
Absolutely.
I appreciate it. Thank you for your comments, and I want to respect everybody else's time. We ran a little over tonight. So for those of you that have not been on meetup.com, I put it in the chat. Meetup.com/JV Partnership is where we have all of our future events and future meetings with the dates. As you see, tomorrow we are not doing part 4. Part 4 is on Friday. I saw some people in the chat saying, I'll see you tomorrow night. No, part 4 is on Friday, not tomorrow. We are skipping tomorrow because we have an in-person local meeting for a sub-2 meeting. in Orlando, so we will not be doing tomorrow's meeting. We will be doing part 4 on Friday. On Saturday, we'll be doing the How to Set Up Your Business with LLCs and Land Trust, which is a great course. You'll learn tons more and go really into depth on how to structure your business and how to set it up properly from the beginning. For those of you that are interested in the recordings, you can go ahead and go to this website here, patreon.com, put it in the chat there. There's over 56 videos on here. They're each at like 2-3 hours long. As you see, we went almost 3 hours tonight. The one we're doing on Saturday is already on there. The ones we do this week are actually already on here. I'll scroll down to where they're at, actually right here. So here is part 1 right here. Here's part 2, here's part 3, and here's part 4. So if you want to go ahead and get ahead of yourself and go on there and watch part 4, you can. And if you want to review the parts that are already on there, the 4 that we're doing this week will get uploaded at the end of the week. I have to have my IT guy help me, but there are a bunch of meetings on there for you guys to watch for $9 a month. You can't beat that value. And then I won't do too much explaining about the JV Partnership Program because Barry basically went into pretty much great detail on it, explain it a little bit. It's basically a coaching and mentoring program by default, but we're really your partner. So this website, jvpartnership.com, also at the top has links, Zoom. So if you go here to the meetup, Zoom meetup events, so that'll bring you right to meetup.com. And then if you go to the Zoom recordings, it'll bring you right to the patreon.com. So if you just want to remember the one website, jvpartnership.com, you'll be able to get access to everything. The program does become free, as Barry was talking to you about earlier. What we're going to do is we're going to show you how to where and generate leads. We're going to show you on what to say to buyers and sellers. We're going to help you formulate all offers. We'll review all your marketing material, help you advise you where to get funds that need to renovate a property, help you fill out all your contracts before presenting to buyer or seller, review all closing paperwork, scope of work for rehab estimates, review all contracts, all aspects of investing in the property. So a little bit of testimonials on here, and then a form at the bottom that will basically give you some more information about yourself and what you're interested in, type of deals you want to work on. So to go into a little bit more detail on how the program becomes free, just so everybody understands it. For example, if we were to do a fix and flip or an assignment deal or a wholesale deal, we made $20,000. You'd get $10,000. We're going to get $10,000 out of our $10,000. We're going to give you back our $6,000 deposit that we require up front, and you never have to put up a deposit for the program again. It becomes free. And then we continue doing deals 50-50 as needed. You're not selling us 50% of your business. It's only the deals you want help on. So you can call us up and ask the generic questions like all the questions that were asked tonight, and we'll answer them for you, no problem. So you're basically hiring an expert in your back pocket so that you have somebody to talk to your sellers, help you close the deals, make sure that you're structuring them properly because you make your money when you buy. So if you haven't done a deal yet and then you're going to do real estate, it's a no-brainer, like Barry said, to join and have an expert in your back pocket so that you know that you're 100% buying a property that you should be buying because, like I said earlier, you make your money when you buy. So that's the most important thing because if you don't structure it right from the beginning and you don't have the right exit strategy, you will get hurt. So it's best to have someone that's done it and has the experience to know how to do it correctly. And then I emailed out this morning our TC packages. We have 4 TC packages for people that want to just have us help them set up the land trust and do contracts for them. Those of you that are on tonight's meeting that were not on last night did not get the email. I'll send it out again on Friday after everyone's been on all the meetings so that we have all the emails listed. I will open it up for any questions about this. If not, we will end the meeting and we'll see everybody on Friday. Remember, Friday, not tomorrow.
Eric, how do you guys help sourcing the deals? Like, do you guys guide us through that too, or have access to deals, or do we just hunt them on the normal way?
So we're going to teach you free and organic ways on how to find leads, whether it be through public records, various different ways of finding free leads, or we're going to teach you the paid method. If you have a budget for marketing, then we're going to teach you how to do mailers. We're going to teach you how to do pay-per-click, set up websites, funnels, all that stuff to basically get paid leads. So it all depends on your budget. You know, if you got to start out organically and do free leads, we'll show you that way. If if you have a budget and you want to set it up on automation and have VAs calling for you, if you've got a 9 to 5 where you really can't spend time during the day making phone calls, we'll show you how to set it up on automation so that you don't have to worry about a lot of the headaches and you're basically just talking to the seller at the end of the day.
And I
So
want to
you
ask
get-
you that. It also depends on what niche of asset class you're going after. Like if you were doing foreclosures, we would tell you where you can get the free leads. I've mentioned them numerous times before about going to the clerk of the court's office. If you're doing mobile home parks, we would tell you where to find those for free or paid. So we have a lot of different cool ways that, is organic to get these leads.
like tax liens,
Yes.
all those like county record stuff. You guys can
Yes.
show how to. Okay.
Yes.
Cool. All right. Thank you.
Eric, do you have like a calendar, like an appointment calendar?
Yes.
Yes,
It's
so
on there.
let me go back there to the website there. So if you look up here in the corner, it says book with Barry, you just click on this and it'll come down here, book a little consultation for 20 bucks for 30 minutes. You click on the calendar and depending on what spot you want, you can request it. If we're available, then we'll accept it. If we're not available, we'll let you know and we can change it. Any other questions?
Who's that handsome guy?
Some guy named Barry. Mike says, thanks, Barry and Eric. Great info from a true REI mastermind. We appreciate that, Mike. Thank you. If you're still on, I don't see that you're on, but thank you. Thank you. Great knowledge. I called, but no answer. Kalu, are you still on? You said you called, but no answer. Did you call the number on the website? Or that number is a Google Voice number. So if I'll put my number in the chat for you guys.
I called the 407 number.
Which one?
That's on
592.
Barry's number.
Okay, so a lot of times what happens is I'll let it, if it's a lot of times it says scam alert, or if I don't know the number and I'm really busy, I won't pick it up. I'll let it go to voicemail. But if you text me first and say, hey, this is Kalora, I need to speak with you from a subject to or something, can I call you? And then I'll say, yes, you can call me now, or I'll say I can call you back in 10 minutes or whatever. So better if you want to reach me, text me
Very
first.
good. Sound
all right.
Because you always see your
there's
text.
a
You always see those.
Okay, so there's a calendar. So I'll probably book the 20-minute calendar then.
Okay. Yeah, sure. Book 30 minutes and then we can speak to you at whatever time you need to. Like I said, if we're available at that time, we'll accept the calendar invite. If we need to change it, we'll contact you and let you know that what time to change it.
Also, which I don't think it shows on when you send out the TC package, but if you become a JV partner, all of those prices are greatly reduced.
Yeah, I did not send that out. I'll send that out on Friday with a reminder, and I'll send out both packages with both prices to show that if you're in the JV partnership program and you want to do it, you don't have to do all deals with us. It's only the deals you want help on. So if you're in the program and you want to do a deal on your own and just want us to do the TC work, those TC packages prices are, like Barry said, greatly reduced.
If we're doing it together, there's no charge.
Right. We include it in the partnership.
And I don't bill anything into it either for that.
Any other questions? If not, we'll go ahead and end it and we'll see everybody on Friday. And then again, we also have the LLCs and land trust meeting on Saturday. Thanks, gentlemen. Wish I could join today. I'll work on it. Work on the money. Yeah. So as far as the deposit goes, we do accept payment plans. So we're not in it for the deposit. We're in it for the 50% of the deals you're going to bring us. So if the deposit is a little bit of a stepping stone for you, we can do payment plans based on your situation. So don't be afraid to ask about that, and we can structure it. We take many people on payment plans because, like I said, and for example, let's just say you do $500 a month, and you're in month 4, you've paid out $2,000, and you get your first deal in month 4. The payments stop and you get your $2,000 back. You don't have to pay out the rest of the $4,000 for the deposit. So that's just a little tidbit for you. Ruben says, awesome. Thank you. You're welcome. All right, guys. See you guys on Friday night. and enjoy the rest of your week, and we'll see you on Friday.
Bye, everyone.